the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to our first day of our fall argument session here in our magnificent Harrisburg courtroom. Visiting with us today are students from Penn State Dickinson Law School. They are members of the Women's Law Caucus, and I had the opportunity to meet them a week or so ago at the PBA Women in the Profession event, which they attended. So we have two 1L students and one 2L. Would the three students stand up so we can acknowledge you? Welcome. We hope you enjoy the session, and we hope no one convinces you not to become a lawyer. The Pennsylvania Supreme Court, as you may know, is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684. Our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. And in 2022, we celebrated our 300th anniversary with a special session in Old City Hall in Philadelphia. We are proud of our rich history. Over the past 25 years, I've had the privilege of sitting on the bench in this majestic courtroom with these beautiful murals by Violet Oakley, a woman of incredible talent and vision. What a treasure this confluence of history and art provides to the people of our Commonwealth. The Capitol Murals project was the largest commission ever awarded to an American woman. Remarkably, Violet Oakley, a young Philadelphia artist, was selected for this daunting assignment at a time when women could neither vote nor hold elective office. Ultimately, she devoted 25 years of her life, from 1902 to 1927, to painting 43 murals in our capital. Violet Oakley went on to become one of the most respected artists in America. I trust that no one who works here takes this gift for granted. While there are many things that our three branches of government may disagree on from time to time, I know that our judiciary, along with our legislature and executive branches, all agree that we have been blessed with the privilege of serving the Commonwealth and that our lives are enriched by the beauty of these inspirational murals throughout our magnificent capital. President Roosevelt attended the dedication of this building in 1906 and declared it to be the handsomest state capitol I've ever seen. The architect of the building envisioned this to be a palace of art, and in no chamber was his vision as well embodied as in this courtroom. On May 23, 1927, the Supreme Court of Pennsylvania convened to unveil the majestic Violet Oakley murals that you see all around you. Miss Oakley had been selected by the Capitol architect Alfred Houston in the hopes that providing such an opportunity might inspire other women to pursue art. At the time, such a commission was a radical concept, and as I mentioned, she was the first female artist to receive a large public commission. Ms. Oakley proved up to the task. Already a well-regarded artist from Philadelphia, Oakley's work in this building made her world renowned. Oakley's vision for this room was to write a book on the evolution of law, and the murals in this room may remind you of the pages in a medieval or Renaissance transcript. Senator George Pepper remarked that Oakley's murals would remind the justices of their solemn duty and the advocates to restrain their passions and compel candor, and that these paintings would serve as a silent but convincing witness to those things without which we build in vain. The remarks from that day were published in Violet Oakley's 1931 portfolio entitled Law Triumphant. A copy of that is displayed out in our hallway and is also available for purchase at the Capitol Museum shop. Attorneys who argued before this court are aware that I like to point out some of the priceless works of art located in this magnificent courtroom. First, though, I'm sure you've noticed that this courtroom is not in its usual pristine condition. In July of 2020, we noticed water damage to the intricate plasterwork that adorns the northeast corner behind the bench. Mr. Minner, could you demonstrate where that project is taking place?
Right above your head.
Above my head. Great. Great. Nice work, Brian. Since that time, in July of 2020, when we first noticed the problem, our Supreme Court Administrator, Chris Nace, and our court crier, Brian Minner, have been diligently working with the Department of General Services and Capital Preservation Committee, particularly Mr. David Craig, to address the water intrusion in what you can imagine is a daunting process in such a historic courtroom here on the 5th floor of the Capitol building. Following extensive exterior repairs made in the fall of 2023 and spring of 2024, this court made the difficult decision to allow conservation specialists to remove the damaged surfaces and allow the underlying masonry to dry. While we are optimistic that the exterior work resolved the issue, additional efforts may be necessary to prevent water from intruding into this space, and our court administration will continue to work diligently to restore this artistic grandeur. I worry about Moses in particular. Brian Minner and Chris Nace have assured me that he will be in good hands. Before the court crier calls the first case, I'd like to briefly remind counsel of a few matters of protocol. Please approach the podium when your case is called. I will then give a brief summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of the facts or procedural history and instead focus on the main issues on which we granted review. Counsel may rely on their briefs for particular issues. In cases where there are multiple parties represented by separate counsel, counsel should not repeat the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues we want to explore further. I remind you that we do not permit rebuttal. Finally, while we have no set time limit for argument in our court, I will advise counsel when we have heard enough, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Henry Earl Ferguson versus Department of Transportation, representing Mr. Ferguson, Mr. Leonard Sava, representing the Department, Mr. Philip Burtnell.
Good morning.
Morning. Please the court.
In this case, appellant was arrested and charged with DUI under the Pennsylvania Motor Vehicle Code. He was accepted into and successfully completed the Accelerated Rehabilitative Disposition Program known as ARD. Approximately 8 years later, however, appellant pled guilty to another DUI. The question in this discretionary appeal is whether treating appellant's earlier acceptance to the ARD program as a prior offense for purposes of determining the DUI-related suspension of his operating license violates due process under the Pennsylvania Constitution. Please proceed.
The legislature has provided that the penalty for every DUI offense except one includes a license suspension. The legislature decided that the least serious DUI offense, general impairment, A2, does not carry a license suspension when you are convicted of general impairment. Mr. Ferguson was convicted of general impairment. This is the current case, and that carries no license suspension. Now, it's been well established for over 100 years that penalties can be increased if somebody is a recidivist, has a prior conviction. The nub here is what's fundamentally unfair and denies due process is that an ARD disposition, as just about every member of this court has recognized, carries with it no factual determination of guilt at all. It's the polar opposite of a conviction. So enforcing a one-year suspension...
It's not the polar opposite. I mean, is that a bit of an overstatement?
I don't think so.
There's been no finding of guilt. There's no conviction. But to say it's the polar, I would think the polar opposite of a conviction is an acquittal. Maybe I'm splitting hairs.
I think they're both polar opposites, actually, because the conviction...
How many poles can there be?
Pardon?
How many poles can there be?
I guess two from my viewpoint. That the conviction is proof beyond a reasonable doubt. I called ARD the polar opposite because ARD is no proof. Clear and convincing evidence would be somewhere in between, proof by preponderance of the evidence, but ARD involves no evidence at all of guilt. So that's why I call it a polar opposite.
Why are your Elaine arguments in play here? This is a civil collateral consequence. Why are we not in a totally different analytical universe?
We are, in the sense that Mr. Lysott did not raise any Elaine claim. The universe that we are in, substantive due process, applies equally fundamental fairness to civil cases and criminal cases, and I will talk about that a little bit. So PennDOT raises a couple of arguments in addition to what the Commonwealth Court said, and I want to address all of them briefly because they're contrary to cases of this court and the United States Supreme Court and the statute itself. One argument they raise is, well, this is a rational choice by the legislature for somebody who has failed to be rehabilitated after going through the ARD programs. That's not this statute. The statute is about dispositions, so that somebody has an ARD acceptance disposition is what makes this a prior offense for recidivist purposes.
But you keep saying, I'm sorry to interrupt you again, but you keep talking about recidivism, and this goes to my question about what analytical paradigm we're looking at here. Here, what we're talking about is a person who goes through ARD and gets that education, learns about the seriousness and consequences and all the things you learn about in ARD, and then commits a DUI in the future. The question I have is, why can the Commonwealth not impose collateral civil consequences here with respect to driving privileges without offending what this court has called the esoteric concept of substantive due process?
I don't think in this case, I'll get to it, I don't think it's esoteric at all in the circumstances of this case. First
well,
of
it's
all,
esoteric to the extent the words don't appear in our Constitution. So
I know
think
that,
that's what
and
this-
sometimes, and I know you've indicated to it, it's imprecise.
Yeah.
Sometimes
I mean, I think
as far
that's
as
why
standards.
this court in Con used the word esoteric in 2004. I wasn't on the court, but I assume when they said esoteric, they were talking about that. So go ahead, I'm sorry.
And in Middale, you wrote an opinion on statutory grounds rather than the constitutional grounds. So first of all, your description of having gone through the ARD program and everything, that has nothing to do with this statute. This is a recidivist statute. The only reason that Mr. Ferguson is subject to a one-year suspension is because of Section 3806. It provides, under the penalties of 3804, that if you have a prior offense, you get this penalty of a year's suspension. So it's a recidivist statute, and the problem is they've included within the recidivist statute, they've equated ARD with no proof of guilt with a prior conviction of proof beyond a reasonable doubt. The statute itself, it is the disposition of accepting ARD. It's been held over and over again. That has nothing to do with guilt or innocence, and it's the moment you accept ARD that you have a prior offense. So, for example, if a defendant accepted ARD and then left the courtroom and went and got drunk and got arrested and convicted of a DUI where the incident happened 3 hours later, he would have a prior offense because he accepted ARD. And that's what's fundamentally unfair. And I do want to talk about, you mentioned Elaine and procedural rights, because the Commonwealth argues that there were some procedural rights here. He has a hearing. Of course, the hearing's not very meaningful because all as explained in Commonwealth Court in Ferguson, all that you have to prove at the hearing to get the recidivist sentence is the prior disposition, that you accepted ARD in the past. More fundamentally...
Counsel, before you get more fundamental, let me get more fundamental, just from my perspective. The statute requires a prior offense. What's the definition of offense under the code?
Section 3806, the statute at issue, lists various dispositions.
But what is an offense? Is an offense an arrest, or is an offense a conviction?
Well, it's certainly not an arrest. I was just going to use that as an example. An arrest is not an offense because somebody is presumed innocent. It proves nothing in arrest, and I was just going to talk about that.
So offense as defined requires a conviction of certain misdemeanors.
Yes, it would be an interesting constitutional question if 3806 had some kind of disposition that was short of a conviction or an adjudication. Juvenile adjudication is proof beyond a reasonable doubt.
But the General Assembly specifically added applications to ARD.
And that's why it's unconstitutional. That's exactly the issue. That is the issue. Is it constitutional? And the answer should be no. And let me use...
And what standard do you define the unconstitutional rational basis?
It's a rational basis test of whether something is fundamentally unfair. Fundamentally unfair is the standard. And if I could just do the procedural substantive distinction just for a moment, because it ties in, I think, with some of the questions. This court a couple of months ago in Bury, as the court had Commonwealth versus Bury, ruled as it had in many other nothing. An arrest proves nothing by itself.
Counsel, isn't that the criminal context? I mean, just...
An arrest, no, because this court has held it in other contexts. Arrest proves nothing in any context.
Yeah, but in this particular case, the General Assembly's included ARD. In other words, if the compelling governmental interest in this particular case is highway safety, and this court's already opined that highway safety is in fact a legitimate governmental interest, what's fundamentally unfair about saying somebody who took a prior arrest and entered into an ARD program and went through the actual process itself of learning about highway safety, the dangers of drunk driving, we're going to make that person ineligible for the collateral civil consequence of a non-licensed suspension. I'm not talking in the criminal context where we're talking about a mandatory enhancement. In this particular case, you're just saying this person doesn't get the benefit of a collateral civil consequence of not having a license suspension. What's fundamentally unfair about that?
It's fundamentally unfair because this is a recidivist statute. The person is not going through an ARD program.
I understand. You keep saying it's a recidivist statute, but basically it just makes him ineligible for the actual non-license suspension, which is a collateral civil consequence, as Justice Wax.
That's right. So the label civil doesn't determine constitutional rights. That's what if I could get to giving a
So
few
you believe that a
examples.
driver's license is in fact a constitutional right? Is that
To
what you're telling?
retain your driver's license is a procedural due process right. This court has held it in Middale and Bell versus Burson in the United States Supreme Court in the 1970s
So
held
you're
it
going
as
back
well.
and forth with procedural
The word
and
privilege, in other words, a word privilege is only a starting point. It's a label. So it's okay if the Commonwealth Court wants to use the label privilege. But we're talking here about a protected...
Which horse are you picking to ride on? I thought we were talking substantive due process, but you just
are.
jumped on to procedural. Which horse are you picking?
Oh, I'm
You
picking,
want to ride both horses?
no, I'm picking substantive due process.
Okay, because you just used procedural.
Yeah, your argument was procedural.
What did I just... I don't even remember.
You said procedural, that's why we're going back and forth on it. So we have to pick.
Oh, I'm not sure. I don't even remember how I used the word. I'm sorry. This is substantive due process. If I haven't answered the question, if you pose it again, I'll answer it again if I didn't answer it adequately.
I think you're doing fine. You answered my question. You might want to answer Justice Wax.
Okay.
Thanks.
So the example I was about to give was Bury. This court decided Bury a couple months ago. Court held an arrest means nothing. We can change the context of arrest from criminal case, civil case. You can't have a penalty for an arrest because an arrest proves nothing.
But see,
People are presumed innocent.
that's the analytical problem. You keep jumping to the criminal cases. This is a collateral civil consequence, and your challenge has to be that the General Assembly has been irrational. It's irrational, such that the arbitrariness of the law offends substantive due process, as that's been defined by this court and the Supreme Court of the United States. And coming to Justice McCaffrey's question, given the compelling government interest in highway safety, how is the civil collateral consequence of a license suspension offending substantive due process? There's a heavy presumption of constitutionality. How do you overcome that without going into criminal law?
I overcome it because the standard is not irrationality for substantive due process. It's whether something is fundamentally unfair. And it's fundamentally unfair where there's no proof of guilt to consider it as a prior offense. We're dealing with this statute, not some other statute, this statute.
But where are you getting the guilt from? The statute specifically defines a prior offense as acceptance into ARD or conviction.
And that's why it's unconstitutional, because it includes ARD disposition. So if I may give some examples, the word civil is not a magic word that takes away somebody's constitutional rights. I mean, and as I said, we're talking about somebody retaining a driver's license. You have a procedural due process. The state has to have a legitimate reason. So let me give just a few examples. Everything I referred to is in my brief. A few examples of fundamentally unfair civil due process cases from the United States Supreme Court and this court. Okay, the United States Supreme Court had a case, State Farm. I don't remember the rest of the site. State Farm, where State Farm, a civil case, they were liable for compensatory damages, and the jury found they were liable for punitive damages. And the jury, or the judge, I think it was a jury, $145 million punitive damages for State Farm Insurance Company. The United States Supreme Court held this was unfair, fundamentally unfair, even though State Farm was deserving of compensatory and punitive damages. It was excessive, the court decided, fundamentally unfair. Civil case, violation of substantive due process. Nelson versus Colorado, a more recent case. Nelson versus Colorado involved two criminal defendants, so it is like this connected to a criminal defendant's case. Nelson versus Colorado, two defendants were convicted of various offenses. Later, they got their convictions reversed, not because the evidence was insufficient, they got there for some trial error. And one of the two, the charges were dismissed. Colorado didn't proceed to another trial. The defendant sued Colorado to get his money back that he paid for costs, fees, and restitution when, as a result of his conviction, that's what he got, he deserved as a result of conviction. The United States Supreme Court held that he's presumed innocent again. He's presumed innocent. Colorado has no right to the money, and they have to give him the money back.
Let's bring it back to the Commonwealth. You indicated that Middahl supports your position. Share with me how, because in that case, this court said it was a violation of due process to effectuate the suspension 2.5 years later. This is a factor where it was only 2 days later. So how does Middahl support you? I see that case as completely distinguishable regarding due process. We found it upon due process, but it was a 2.5-year wait. So following your logic that you said this case stands on Middahl, you're telling us that 2 days notice is a violation of due process. Is that what you're arguing?
No, because this is not a length of delay violation of due process.
So then share with me how Middahl supports your position.
This is more compelling than Middahl, not less. Factually, this is more compelling, and I'll explain why.
Yeah, explain that. 2.5-year wait to be suspended as a license suspension as opposed to 2 days? This should be interesting.
Thank you. So Middahl was convicted of an offense that carried a license suspension. The license suspension was not challenged. It was constitutional. Went along with the statute that he had a license suspension that was merited based on the offense he committed. This court decided under the circumstances of Middahl, the particular circumstances, they didn't effectuate the penalty that was authorized for 28 months. They didn't have a good reason, and Middahl was prejudiced. So the court balanced these three things to decide that it was fundamental. I'm using the language of Middahl and the language of all the other cases. Fundamentally unfair to have a license suspension in Middahl. This case, under the statute, he is unconstitutionally receiving a license suspension. There's no balancing. After Middahl, no, Justice Wecht, your opinion going on the statutory basis, you said substantive due process, it's very imprecise. Middahl, it's going to be imprecise in the future as far as applying substantive due process, because you're going to have to look at what's the length of the delay. Somebody brings up unjustifiable, what's the prejudice? Before it rises to the level of being fundamentally unfair, violation of due process. This is no balancing. It's fundamentally unfair to sentence somebody as a recidivist when there is no, and that's what he sentenced under this statute. We're not talking about any other statute that may arise in the future. It's fundamentally unfair where there's no proof of prior wrongdoing to impose a penalty of a license suspension. It's stronger than Middahl. Middahl deserved a license suspension. This court decided it was fundamentally unfair the way it was effectuated.
Well, that again, the turning the circumstance upon which Middahl turned was the governmental, the exceptional governmental delay. That's what made it fundamentally unfair.
Yes.
It's entirely different, as Justice Doherty was exploring with you, from this is a definitional challenge, as it were. In other words, your problem, going back to what you were saying a few moments ago, was with the General Assembly's very choice in 3806A to define within prior offense acceptance of accelerated rehabilitative disposition?
Yes, because there's no proof of guilt. It is fundamentally unfair to label him a recidivist and as a recidivist give him a 1-year penalty. If he was convicted, fine. The legislature, what they did is the starting point for constitutional analysis. I have no dispute that the statute says that. The legislature has no right.
Why is it not satisfactory from a due process, substantive due process perspective that people accepting ARD are deemed to be on notice that there could be collateral civil consequences of their acceptance of ARD?
There is no notice given, and there's no waiver of rights, constitutional rights, at the time when somebody accepts ARD.
Ignorantia lex non excusat?
I have no idea what that means.
Ignorance of the law is no excuse.
That doesn't apply.
ARD,
If that was true, no person could challenge the constitutionality of the statute. Every person who appears before a court and later is subject to unconstitutional action, they wouldn't have a chance. Separation of powers problem, that phrase, ignorance of the law is no excuse, comes from the criminal law and is only there because people who violate our criminal laws, for example, a kidnapping case where somebody says, I didn't know kidnapping was illegal in this country. I just came over from my country. In my country, and I'm using an actual case example, this was a kidnapping of a woman. And he said, in my country, you kidnapped a woman who you want to be your bride. That's where the phrase comes from. Only in the criminal law, because there are societal prohibitions on conduct, you cannot make an ignorance of law defense. This is way different. In other words, constitutional rights, doesn't matter that you know of an unconstitutional statute. You can still challenge it when it applies to you, which is our situation. Almost every member of this court has acknowledged that accepting ARD does not prove anything. There's no factual determinations at all. Justice Doherty's opinion in JF versus VHS noted that there's no factual determination of guilt in an ARD proceeding, and that's why under that statute it had to be treated differently than the other dispositions were listed in the statute, juvenile adjudication and a conviction. In Verbeck, 3 members of this court, Justice Todd, along with Justice Wecht, and Justice I did this the last time.
You did.
I did.
And
Sorry.
see, this doesn't bode well for you.
No, I'm sorry. I did this the last time. Justice Doherty's opinion was joined by everybody except Justice Mundy. You have the 3 people. Sorry.
You're digging a deeper hole, really.
Yeah, I'm sorry. I want to mention one more case. And this is why I've appeared before this court in many of these cases. And that's Commonwealth versus Chichkin. That was my case. So lawyers have looked to me for related litigation ever since. And that's the case where Justice McCafferty decided. And in that case, there were 2 issues raised. One was the Elaine violation, and the other claim was a violation of substantive due process rights. I raised the exact same claim that I'm raising here in that context. And Justice McCafferty decided it's unconstitutional on both grounds, substantive grounds and procedural grounds. The procedural ground was the Elaine violation. The substantive ground was that the person had committed no conduct under the law. Under the ARD rules, there's no factual determination, and you can't be considered to be a little bit guilty. And the main case that Justice McCaffrey relied on in the substantive due process analysis was Nelson versus Colorado. Nelson versus Colorado, which I started to talk about, is the case where you had two criminal defendants. Their conviction was reversed on procedural grounds, each of them. One of them, they just dropped the charges. They didn't go for a retrial. I'll just deal with him.
But it's a procedural due process case, Matthews versus Eldridge, right? It was the one guy hadn't been through the whole process. Wasn't that a matter of This case is not about process.
Either was that one.
What?
They didn't label it in the end. No, in the end, let me just say it. In Nelson versus Colorado, in the end, did not label it procedural or substantive. It's clearly substantive, though. I'll explain why. Because, in fact, the dissent criticized the majority in Nelson versus Colorado because it said, in essence, you decided this case on substantive due process grounds, but you haven't used the word because counsel didn't raise it. So, in essence, I'll explain why it's a substantive due process case. After the convictions were reversed, defendants sued civilly Colorado to get back the money paid for the cost fees and restitution. And Colorado has statute that would make them go through hoops to try to get the money back, basically. And the United States Supreme Court said, once those convictions were vacated, the presumption of innocence comes back. And remember, and contrast that, by the way, with this case. There is no prior conviction in this case. There's been no factual determination at all. Once the convictions were reversed, he is presumed innocent again. And because he is presumed innocent, the state has no claim of right at all to that money. This is a civil case. No claim of right at all. And quoting Justice McCaffrey, quoting Nelson versus Colorado, you can't be considered somewhat guilty. And if you're not somewhat guilty, in other words, because you're presumed innocent, you can't extract this civil penalty.
So let me just unpack.
It's a civil penalty.
Can I unpack that? So you want to analogize this to Nelson. So there you have a guy, he's convicted, his conviction is overturned, and he successfully sues to get his fines and restitution back. And that comports with, I think, notions of due process. Okay. How is that like a case where a guy accepts ARD, goes through the education and whatever, has no conviction, but then falls into a circumstance where he is later convicted of DUI, and the legislature has said acceptance of ARD in the past is a prior offense for purposes of your driving privileges. How is the Nelson case like this case?
It's exactly like it, because several times now there's been a mention of somebody going through the program, and after going through the program, what's wrong with what the legislature did? That's not the constitutional question today, because, as I use my example, it's the very moment you accept ARD. 3806 talks about dispositions, conviction disposition, adjudication delinquency disposition, ARD disposition. Well, what's wrong with that one compared to the other two? There's no proof of guilt. He's presumed innocent of the ARD
for criminal,
case.
There can be no criminal consequence under a lane of that. We've said that, right? But again, this is a judgment by the General Assembly about a collateral civil consequence of something they defined as a prior offense. There's nothing about guilt.
The legislature labels don't determine this. That's what's been wrong with the Commonwealth Court decisions. They say driving's a privilege. Okay, well, that ignores the fact that that privilege is a protected constitutional due process right to retain your license unless there's a valid reason for taking it away. Middale is just one of the cases that explains that. Two, and this is the sole basis for the Commonwealth Court decision. Two, this is a civil case. It's not a criminal case. That is irrelevant for substantive due process purposes. This is not about the procedures. You could have, let's say the statute required that a defendant can get a hearing and the PennDOT has to prove beyond a reasonable doubt that he accepted ARD in the past. The statute is as unconstitutional as the current one. You can give all the procedural rights in the world. You could say they have to prove beyond all doubt that he accepted ARD. The problem is when you have all the procedures in the world and what you're proving is not something that is a constitutional basis for the penalty. The Berry case that this court decided just a couple months ago, arrest could not be considered at sentencing because it can't be a factor. It doesn't prove anything. It doesn't prove anything at all.
Counsel, isn't that the problem with the inclusion of acceptance of ARD within this concept of prior offense? Because the underlying the inclusion of acceptance of ARD is a presumption of guilt.
Yes, and it is in essence.
It's not, as some of my colleagues have described this as, what's wrong with taking a license away from someone who has gone through, training courses about not driving under the influence. That's not what's underlying this. It's not the fact that you go through the training course.
We can't ignore the statute.
Here. It's included as a prior offense based upon a presumption of guilt by accepting that ARD disposition.
Yes, and that's why I've been talking about Nelson versus Colorado. It is, in essence, because there's no proof of guilt at all, as every member of this court has recognized, it is in effect like an unadjudicated arrest. In effect, because there is no proof of guilt, okay, at the ARD proceeding. So let me get back to Berry for a moment. In Berry, this court decided it's unconstitutional to consider arrest as a sentencing factor. Why? Because we've held over and over again, arrest proved nothing at all. So let me now make up a statute for the Commonwealth. Okay, the legislature passes a statute that says arrest can be considered at sentencing if the Commonwealth proves beyond a reasonable doubt that the defendant was arrested before. Okay, we've given procedural rights to a hearing, proof beyond a reasonable doubt that he was arrested before. That statute is unconstitutional because, for the reasons the court said in Berry, it's proof of nothing.
Right, we
you
said
can
that
give all the procedures in the world.
Right. We said that in Berry clearly, and that's as a sentencing factor. So, is there any case from our court that jumps you over the chasm to collateral civil consequences?
Well, if you give me as the court held this in the past, no, this is an issue of first impression. But all the cases I've cited fully support what I'm arguing here today. Once you get beyond labels, which is all the Commonwealth Court relied on, once you get beyond labels, privilege, civil, and all that, substantive due process applies. So that my example of Berry, let's say the legislature passed a statute that said at sentencing, if you prove beyond a reasonable doubt that the person was arrested before, you may consider it sentencing. Okay? It's good procedurally, proof beyond a reasonable doubt, except what you're proving beyond a reasonable doubt is worth nothing.
Mr.
That's
Chosnoff?
You can't do a license suspension for a year based on an ARD disposition which proves nothing. And that's why I call it the polar opposite of the conviction. And so this is an issue of first impression, but it's fully supported by all the cases that I've cited. Basically, it's a half dozen cases, I think, that very clearly define the parameters of this substantive due process challenge. And I've mentioned most of them.
I think we understand your argument very well. It's been well presented. Are there any other questions? Hearing none, then we'll go over to hear Mr. Bricknell.
Thank you,
sir.
May it please the Court, my name is Philip Bricknell, and I represent the Department of Transportation's Bureau of Driver Licensing. The Bureau asks that this Court affirm the Commonwealth Court because it correctly decided in its unanimous en banc decision that Mr. Ferguson should receive this driver license suspension. The Commonwealth Court's opinion respects the General Assembly's policy determination in 3806A that drivers who commit a second DUI offense after having accepted ARD for a DUI offense warrant a greater civil consequence than those drivers who have not been afforded the opportunity of ARD. Commonwealth Court recognized that the issue that was raised by Mr. Ferguson was whether that second DUI triggering a suspense, or actually not allowing him the advantage of the exemption from suspension, whether that situation was a violation of his procedural or due process rights. That was the issue that he raised. Commonwealth Court acknowledged that was the issue, but did not get into a due process, either procedural or substantive analysis, because there was no need to get into that level of analysis, because this is merely a statutory interpretation case. In a situation like this, where the statutes are clear and unambiguous, and the statutes have been interpreted consistently with those unambiguous terms, the statutes do not violate, and the statutes do not violate a clear right, constitutional right or command, then the courts can decide the issue merely on their clear and unambiguous wording. This is the principle of constitutional avoidance, and so Commonwealth Court did not address due process because the statutes here answered the question that Mr. Ferguson should receive the suspension, because that is the policy determination that the General Assembly made and instituted. To address some of the issues that were raised—
Counsel, can I just ask a question that just troubles me about this entire concept? What has the legislature done here? I mean, do you have to do something wrong in order to have your license suspended? And if you do, doesn't somebody have to determine that you have done something wrong before your license can be suspended? To me, this question is as basic as that. And if there's no determination of guilt or that someone has done something wrong, how does the legislature then say, without us blinking, that their license can be suspended?
Your Honor, the General Assembly did make that determination.
What determination? That you could suspend someone's license without a determination that a license holder has done something wrong?
Well, more specifically than that, Your Honor, what the General Assembly determined was to draw the line at the acceptance of ARD.
But see, that's where my hang-up is with this, because drawing that line at the acceptance of ARD, if you follow my logic, would mean that they believe that that license holder has done something wrong in the past. Mm-hmm. I mean, otherwise, it doesn't make any sense. I mean, you can't have your license revoked without doing something previously that could tag you as an individual who's going to lose your license. This individual has never been determined to have done something wrong, or, to use the language we've been using, found guilty.
Right, Your Honor, but it is not that a vacuum where the person, just an arbitrary line was drawn. Other states have drawn the line in different places. The General Assembly here could have included in the definition of prior offense somebody who was arrested and charged with DUI and then null-prossed or acquitted. And other states do that. Other states suspend driver's licenses on
And you're defending that?
No, Your Honor.
Okay, because I don't see the difference.
No.
I mean, that's what my problem is with this. I get it. You know, the legislature can make a determination that a license suspension can occur under certain circumstances where you're dealing with an individual who has been proven to be unworthy of holding that privilege for some period of time. But this individual hasn't been proven to be unworthy of anything.
Well, Your
Maybe
Honor,
the problem is the ARD statute. I mean, we deal with this all the time. I mean, maybe there's a problem with this underlying concept that there's no admission of guilt, but there isn't.
Or is it that they're waiving their right to a trial to be accepted into a diversionary program such that they are aware that they have been charged and have a right to be either found guilty or not guilty? So the General Assembly made a policy decision that if you accept that diversionary program and fall with another DUI within the time frame, that you are aware that it falls within the General Assembly's policy of protecting pedestrians on the street or others from drunk drivers.
that's right, Your Honor, or deterring future DUIs.
Well, just maybe you could just refresh my recollection. What rights are you waiving when you accept ARD?
Well, I've never actually practiced criminal law. My understanding that acceptance into ARD, and just to be clear, ARD is not something the driver accepts. The driver has to ask for ARD. My understanding is DAs will then say somebody will be admitted. So, and I think that's a big distinction because that gets you further down the process. We're not talking about somebody just at the moment of arrest being told you're being suspended. We're talking about somebody who's arrested, charged. The process begins, the process of prosecuting that person. If the DA decides to offer them ARD, they go into ARD, and I understand there's a lot of loss of rights. For example, you can't drink while you're under ARD. You are subject to probation visits while you're in ARD. You have to comply, I believe, with tests of your blood under ARD, so there's a lot of loss there. And importantly, ARD usually triggers a driver license suspension. In this case, Mr. Ferguson received a 60-day license suspension when he was accepted into ARD in 2012. And so no finding of guilt, no proof of wrongdoing, but acceptance into ARD triggered at that time a 60-day suspension.
And the question, counsel, you tell me if I'm right about this. The question for us is, did the General Assembly's decision to say, as a matter of law, that acceptance into such a program cannot lead to a collateral civil consequence of a driver's license suspension upon the conviction of a subsequent DUI. Isn't that the question? Whether that fails substantive due process?
Well, yes, and I think the issue there with the substantive due process is, as was mentioned just a moment ago, there has to be something irrational about what happened. There has to be something that's an outlier. So in Middaugh, the outlier was the 28-month delay and the absence of how to address that under the statutes. There has to be something irrational, something that the court can point to and say the General Assembly could not have meant that outcome. And
Isn't that exactly what we have here, where the General Assembly has decided to consider something that is not what it thinks it is? It is not a finding of wrongdoing. It is not a conviction. It is not an admission of an offense. How logically can that be in that list of considerations?
Well, because the previous argument, the assertions by Mr. Ferguson, blurs the line between the criminal and the civil. Really, there's quite a distinct divide between the criminal and civil sanctions, and the department completely agrees that on the criminal side, acceptance of ARD is not equal to guilt. It can't be used as an equivalent of guilt.
And why is it different in the civil side?
Because there are less standards and we have less protections on the civil side. We have a lower standard of proof.
Counsel, can I just split that hair?
Dan, I'm not quite finished.
I'm sorry.
So how about if the statutory language read, all these factors that can be considered, and if the individual has been stopped for speeding 3 times in the past, not issued a citation, not arrested, but stopped for speeding, that to me wouldn't make any sense. Does that make sense to you?
Well, Your Honor, and the system isn't set up that way. At this point, if a driver was stopped and not arrested, not cited, my client would never know. The way the system is set up, the way it works, my client is informed of all convictions, and my client is informed of the acceptance of ARD because of the structure.
Is it informed of citations? What if a citation was issued in each of those?
It is not informed of citations, Your Honor. It is only informed upon conviction, whether that triggers points being added to their license or a suspension. It is only the convictions and acceptance of ARD that the General Assembly, in the structure that they have set up, those are the triggering events. And in this case, the acceptance of ARD, in addition to the aspects of the program that limit the individual's rights, has this follow-on effect that if they have a subsequent DUI within 10 years, they will not be allowed to take advantage of the exception from the driver license suspension that is very limited. It's only for a general impairment where there are no prior offenses.
The individual accepting ARD admits to being a first-time offender who's accepted into a program for purposes of rehabilitation and following the rules. So I would assume the General Assembly is permitted to make a public policy by saying if an individual, as opposed to being convicted, wishes to accept responsibility for rehabilitative natures regarding alcohol, that can be subsequently used by the General Assembly to suspend a license civilly should a person resume or fail from rehabilitation and use alcohol and getting behind the wheel. Correct?
That's correct, Your Honor. The General Assembly, not only have they allowed the ARD system to be set up, which is a very popular option for people who have been charged with DUI because it is the most efficient and least expensive way of getting through a DUI citation or charge.
It's for first-time offenders, and it saves the state the cost of a trial. But one must admit in accepting ARD that they will be subject
Statute of limitations defense. That's all they do.
No,
I mean, that's what they do. So I think Justice McCaffrey had a question.
No, actually, Kevin, Justice Doherty actually asked my question
Okay.
word for word, but just to point of clarification, there is an admission policy. Before you make an application for ARD, the defendant has to make an application to the DA and admit as part of that application process that they are a first-time offender. That's exactly what Justice Doherty is saying. The penalty in this particular case is an administrative penalty. It's not issued pursuant to either the ARD admission program or if it's a subsequent DUI offense. It's not like the DUI judge is saying your license is suspended for a year. That's a civil collateral consequence that's issued by PennDOT, which is a completely separate proceeding with a different standard, which is what Justice Doherty was saying. That's all. I wanted to make the point Justice Doherty just made.
Well, so is it your understanding then, and I don't mean to ask questions to my colleagues, but is it correct then that by saying I'm a first-time offender, you're not saying this is the first time I have been charged with an offense, I'm a first-time offender, you're saying I'm guilty?
No, you're saying it's the first time I've ever been arrested and I'm eligible. ARD has certain eligibility requirements.
But how is that an admission?
There is no admission. I think, can I
You're
follow?
making a
Counsel,
representation.
The issue here is not, correct me if I'm wrong, the issue here is not that the General Assembly has imposed some judgment of wrongdoing, as has been bandied about, but rather that they've apparently made the legislative judgment that this category of people have been through this particular program, and if they've been through this particular program in the past, then if there's a conviction, there's going to be a collateral civil consequence, and the judgment we have to make is whether that classification comports with substantive due process. Isn't that the question we have before us?
I believe that is, Your Honor.
So it's not a question of whether the state has come and said he's wrong or he's a wrongdoer. And there's no issue here about a criminal. He's not been convicted prior. There is no prior. For criminal purposes, it's a nothing burger. But this is not about crime. This is about a collateral civil consequence. Isn't that the important distinction?
Yes, Your Honor, among a number of important distinctions here.
Yeah, but counsel, back to my point. This isn't a determination, as I understand it, that somebody's losing their license because they were stupid enough to go through a program to teach them about not drinking and driving. I mean, it has to be based upon the fact that they went through that program because they did something wrong.
Well, actually, Your Honor, I think again, there's a blurring of the effect of ARD and the acceptance and what that means back in 2012 compared to what happened in 2020, which is in 2020, Mr. Ferguson was arrested, charged, and convicted of DUI. And so he did something wrong in 2020. And that's why the Common Pleas Court in Cumberland County simply said the only issues are, did Mr. Ferguson meet the requirements to be suspended now in 2020? And he did. He was driving while intoxicated. He was convicted of driving while intoxicated.
But but that suspension, after he was convicted of that later, was not because he, quote, did something wrong in the past. There's no such thing in the law that he did something wrong. He was not convicted. That was an ARD. It was a nothing for criminal purposes. The question is whether this statute that says acceptance of a prior ARD can have a later civil consequence. We keep talking about wrongdoing. It has nothing to do with wrongdoing. It has to do with whether this statute about acceptance of ARD having a collateral civil consequence offends due process. That's
right.
The question.
The second one, the second DUI, means that because it came after ARD, which included, we've all agreed, that affirmation of some involvement, does not allow him to enjoy the exception in Section 3804 E2 III, because that's the way the scheme has been set up. It is mandatory. My client has no discretion to do anything but to impose a suspension under these circumstances. And it's not an unusual circumstance. I looked at the records from the 5-year period from 2014 to 2019. There were 3,372 licensees in Pennsylvania who were accepted into one form or another of ARD for a DUI and had a subsequent DUI within the 10 years and received a suspension for that. This is not an outlier situation. There are any number of reasons why a driver could decide to go, having been arrested and charged, could decide to go into ARD. Even if they believe completely that they are innocent, they may decide that that's the best option for them. But the General Assembly has decided that if that driver does that and has a subsequent DUI, based on the General Assembly looking at that program, that they will not allow that person, if they get a general impairment DUI for their second offense, to be excused from the license suspension that all other DUIs receive.
And that's consistent with the state's interest in promoting roadway safety.
That's right. Well, two interests, Your Honor. Promoting roadway safety by immediately removing the suspended drivers, but also the deterrent effect, which serves the same purpose of stopping people from driving to begin with when they're under the influence. But, and actually, I read, even though I don't do criminal law, I read through every word of Verbeck several times, and it looks like really, for Verbeck, if we're going to talk about the criminal law, it really is heads, PennDOT wins, tails, PennDOT, Mr. Ferguson loses, because the court split there. Half the court said ARD was okay for use in criminal sentencing, so if it's okay there, it certainly would be okay in PennDOT's area, and the other half said it isn't all right to use ARD because of all the criminal law protections, but this isn't a criminal case. This is a very clearly different civil case, and that's not just a matter of labels. There really is a distinction to be drawn here with how courts review what my client does under the statutes and the vehicle code.
All right, we understand your position. Thank you very much.
Thank you very much,
both. Mr. Minner, would you call the next case?
T.G.A. versus the Department of Education and R.W. versus the Department of Education. Representing T.G.A. Mr. Scott Stedman. Representing R.W. Mr. Richard Steven. Representing the
No, I'm good. Thanks.
Ms. Nadia Neal and Mr. Anthony Walker.
you all have a lot of papers with you. I hope that's not indicative of the length of your arguments. Good morning.
Good morning.
In these appeals, T.G.A.'s teaching certificate was immediately suspended following criminal charges being brought against him. His suspension was posted on the websites for the Department of Education and the Professional Standards and Practices Commission. Ultimately, T.G.A. was acquitted of the charges brought against him, and his criminal record was expunged. Thereafter, the department brought misconduct charges against T.G.A. based upon the facts underlying the criminal charges. These charges were dismissed and expunged from T.G.A.'s personnel file. The department and commission's websites were updated to state that T.G.A.'s suspension was lifted, but they continued to note the fact of his prior suspension. Similarly, R.W.'s teaching certificate was immediately suspended after criminal charges were brought against him. R.W.'s suspension was posted on the same websites. Ultimately, the charges against R.W. were null-prossed, and his criminal record was expunged. The websites were updated to reflect that R.W.'s suspension was lifted, but continued to note the fact of his prior suspension. We consider whether the refusal of the department and the commission to remove all references to a suspension for criminal charges which have been dismissed due to an acquittal or because the charges have been null-prossed violates the Pennsylvania Constitution's right to reputation and to pursue a chosen profession. Please proceed.
Good morning, and may it please the court, my name is Scott Stedgen, and I represent the appellant T.G.A. My colleague, Richard McEwen, represents the appellant R.W. It is an honor to be arguing in front of this court. At the court's urging, and because the cases involve similar issues, we decided to divide the argument by issues as opposed to by cases. We will be addressing the two questions raised in this court's aliquot grant for the R.W. case. I will be explaining how the Commonwealth Court and the appellee's interpretation of the Educator Discipline Act violates the Constitution. And Mr. McEwen will be addressing how the statute can and should be construed to effectuate the intent of the General Assembly and avoid the constitutional concerns. Of course, if there's case-specific questions, either one of us can answer the cases. Because I'm the first of four presenters, I think it's important to start with an explanation on how this act was applied in these two cases. T.G.A. and R.W., who at all times relevant were professional educators certified by the Department of Education, were both charged with very serious crimes. Under the school code, employers are barred from hiring educators who are convicted of one of 20 or so very serious crimes articulated in Section 111E of the school code. These are very serious crimes. They include homicide, sexual exploitation of children, rape, kidnapping, and the like. Both T.G.A. and R.W. were charged with one of these crimes. Section 9B of the Educator Discipline Act, entitled Discipline for Criminal Offenses, requires the Professional Standards and Practice Commission, which is an agency created by the General Assembly to oversee the educator discipline system, to revoke educators who are convicted of 111E crimes. But recognizing that it takes a long time for criminal charges to go from inception to conviction or acquittal, the General Assembly included a measure in Section 9B of the Act intended to protect the school community while the charges were pending. Section 9B(a)(1) requires the Commission to temporarily suspend the certification of teachers charged with one of these crimes while the case is pending in the trial court, if the Commission determines that the educator poses a threat to the school community. If the educator is ultimately acquitted, the charges are dismissed, or the charges are dismissed, the suspension is immediately lifted. If the individual is convicted, the educator's certification must be revoked. There is no discretion in the Act given to the PSBC, the Commission, in this regard. In both cases, T.G.A. and R.W. waived their hearing on whether there should be an immediate suspension.
Well, let's stop right there. Share with us, in your analysis, how should we consider that waiver?
I don't think it's relevant because we are not challenging whether or not the individual should have been suspended while criminal charges were pending. That is not an issue today. We are challenging the residual effects of that suspension. Well, the department then, after they suspended the determination, they posted a notice on the website, not only listing that the individual was suspended for being charged with one of these crimes, but it actually listed the crime. T.G.A. went to trial and was acquitted. In R.W.'s case, the prosecutor null-prossed the charges before trial.
And there was no problem with that being listed before the trial, was there?
So, no problem whatsoever. We have to this point, no constitutional concerns. But then, after they were acquitted, both T.G.A. and R.W. had their charges expunged. T.G.A. as a matter of right due to the acquittal, and R.W. through a petition for expungement. If T.G.A. and R.W. were not public school teachers, if they were a teacher's aide, if they were a private school teacher, if they were an independent contractor working in the schools, that would be the end of the story. No one would ever know that these individuals were charged because their record would have been expunged. It's as if it never happened. But because they are teachers, public school teachers certified by the Department of Education, the Commonwealth believes that Section 15D of the Act requires it to post notice directed to the public and to public school employers through the teacher information management system that at one point in history, not now, but at one point in history, the commission believed that the individual was a threat to the school community.
Well, that's because they didn't file a hearing to prove otherwise when the board went to place their licenses on suspension.
Well, I don't know if that is because of that. I mean, they made that determination at that point. And my colleague will explain that determination more, but.
If you were concerned that you were innocent and you were being improperly charged in this arena, and you knew if you were convicted, your certification would be suspended and you would be done, wouldn't it behoove you to fight for the initial suspension of your certification while the process went through so that when the end result came out, you wouldn't have to worry about this part of your license being on that suspended list?
Well, a couple of things. First, you have to remember the individual's under criminal jeopardy at that time. And not many criminal... The individual's under criminal jeopardy at that time. The charges are pending. And not many criminal defense lawyers are going to advocate for making an administrative record while these charges are pending. And secondly, in my case, in the T.G.A. case, the charges for the immediate suspension include 2 allegations, and only 2 allegations related to being a threat. One was T.G.A. is guilty of sexual assault. 2, T.G.A. was charged with sexual assault. And in that proceeding, there's nothing that the individual can do to disprove those facts unless they are having a mini trial on the criminal case. And PSBC specifically says we will not have the trial on the criminal case. That is for the criminal courts to address. They say in this case, in the preliminary injunction hearing, we get testimony from the executive director of the PSBC that says the truth of those questions are not for us to decide. That is for the criminal system to decide. We don't even care about the truth. All they look at is if those charges are true, would that person be a threat?
So if those charges are listed and the suspension is listed, there's really no chance that the teacher could have those removed prior to the trial? Because it's just recognizing the fact of a charge and an allegation.
Yeah, and there's no constitutional concern there because there's open courts and those charges are already public dockets. So there's no problem.
Excuse me, didn't the Department of Education have the burden in the initial suspension hearing to prove that the educator poses a threat to the health, safety, or welfare of students or other persons in the school. And that was the burden of proof on the department, correct?
That is correct. I don't want to go too far into this, but all they have to prove is that if true, if those criminal allegations are true, that someone who is guilty of such crimes would pose a threat. No one's denying that. We're not challenging that he should have been suspended. If it was true that T.G.A. did those crimes, yes, he's a threat and he should not be in the public schools of this Commonwealth. But he did not do those things. I don't think the threat determination is relevant from a constitutional perspective, which I'm arguing. There is no dispute that T.G.A. is not a threat today. After the charges he was vindicated in trial, they brought in separate charges against T.G.A. for violation of the Educator Misconduct Act. And what they allege is that he committed immorality. The same actions that underline the criminal case, he committed immorality. Immorality is an act that offends the moral of community and sets a bad example for students. The commission said he did not set a bad example for students. If he's not setting a bad example for students, he's not a threat. So I don't think that is relevant today. And the department, if they believe he's a threat, they could bring charges against him, which they did. In both forms, he was vindicated. But
I'm sorry.
Yes, go ahead.
And your challenge, just to boil it down, is that notwithstanding that vindication, they still insist on keeping it up on the website.
Correct.
Isn't that it?
Notwithstanding, they want to keep up a record that at one point they thought he was a threat so that the school community can know who they are hiring and parents can know who their teachers are. What that really is acknowledging that we could not do anything about T.G.A. through the rule of law, so we are outsourcing it to the public.
A scarlet A, if you will.
It's a scarlet A, but it's tattooed on him so that he can never get away from it.
In other words, there was nothing he could do once the accusation was made to get rid of the mark of Cain for all time. All time.
As soon as an accusation is made against a teacher, that sticks with, if it is a 111E crime, it sticks with them under this interpretation of the act forever. He did everything possible. He was vindicated at the criminal trial, which is, he faced the power of the state and was vindicated. He did it again at the civil hearing under a preponderance of evidence standard, looking at whether he was a bad example to school children, and he succeeded there too.
But counsel, what about the fact that you're looking at just the notation of the automatic suspension due to the criminal charge, but there's a later, if you look at his record in front of the commission or the Department of Education, it also reflects that the automatic suspension was lifted.
Correct.
So wouldn't one looking at the totality of his record say, well, he had an auto suspension for a charge, but it was lifted. Pennsylvania sees that he's not a threat anymore and his license is intact. Why isn't that adequate to protect his right to reputation?
Well, because I think the purpose of keeping that initial suspension is what I issue today. There is underlying of all of this is somehow a belief that once someone is accused of these crimes, there must be something there.
Well, I understand the purpose. I'm asking you, though, the totality of you seem to be looking in isolation at the auto suspension notation. I'm saying, why should we look at that? Why shouldn't we also look at the fact that the department has noted that it was lifted?
I think you can look at both, but I think that the impact of both together is still the same. You think
the public can't glean anything from the fact that the department lifted the suspension and his license is in full force in Pennsylvania? You don't think the public can glean anything?
I think that a public school employer will not even interview an individual who has listed on that as being charged with a serious offense. They are afraid of what parents are going to say to them at school board hearings.
Is there evidence of this fear in the record?
It's not. No, there's not evidence of this fear in the record. But that's my response.
Has he had a difficulty?
Yes.
There's evidence of him having difficulty finding a job because he's been told.
So he is currently. T.G.A. is currently employed in Ohio. He resides in Pennsylvania and has a Pennsylvania certificate, and he would like to teach in his home state. He has applied, since the notation, he has applied for coaching positions, and he's been denied coaching positions because of the notation. That's in the record. He has not applied for teaching positions because the law does not require someone to do a futile act. He believes that it would be futile. He doesn't want to go to a school district in his hometown and has to tell them, I was once charged with this crime that has been expunged, but answer questions about what the crime was, what were the circumstances. No one else in society, once acquitted and has an expungement, has to explain what happened. It's not on him to explain what happened to him because someone made a false accusation against him.
Counsel, isn't what you're describing pretty much on every job application you've ever applied for? I mean, most people, when they apply for a job application, one of the questions that's presented is, were you ever arrested or charged? You have to answer truthfully on that particular application. And then the employer has to follow up on it. That affects insurance rates. It affects their obligation to their fellow co-employees. I mean, if you hire somebody who's got a past record, you want to know that particular issue so you don't put them in the place where they may endanger another one of your employees, right?
Absolutely correct, and I think that's valid, but not when there is a expungement. When there is expungement, that arrest and that charge is a legal nullity.
Expungement means the charges are gone. It doesn't necessarily mean you can lie on a job application.
It's not a lie. I think as a matter of law.
Have you been arrested for a crime? What are you going to answer on that question?
I would say no if I was expunged.
That's a very interesting question Justice McCaffrey asked. It's actually the subject of great debate with law school applications. But you have another layer here beyond that, right? You have the layer of a public entity, a government entity, maintaining a website which has that mark of Cain or that pregnant possibility posted there for all the world to see against the backdrop of our Constitution's right to reputation that we discussed in the diocesan cases, right?
Correct. And this involves the esoteric concept of substantive due process as opposed to the procedural due process in the diocesan cases.
In addition to that esoteric substantive due process stuff, we've got a slightly more, the words of which are not in our Constitution, we have a much more concrete thing here also. We have the right to reputation, which we've spoken to, right?
Correct. This is a right to reputation, but in the context of a General Assembly enactment, we have to look at whether or not the General Assembly regulated that right beyond its police powers. And in this case, because the reputation is a fundamental right that this court has held as a fundamental right, the General Assembly can only regulate that if it is narrowly tailored to a compelling state interest. I do not see any interest whatsoever in the Commonwealth publicizing that someone was once charged with a crime they did not commit.
Well, isn't that a substantive due process?
Absolutely.
Well, what about, under our charter, your right to reputation is protected by procedural due process. Your right to reputation cannot be taken by the Commonwealth without procedural due process. So let's stick with that for a minute. What procedural due process does your client want to remedy the reputational harm?
We are not arguing any procedural due process issue.
Well, then you're not arguing a right to reputation violation.
I disagree.
The government can take your reputation as long as they give you due process.
No, I think the government can only take your reputation if they have a compelling state interest to do so. I think there are times when the government can put a stigma on someone's good name, and it's justified to do so. If someone is convicted of a crime, it's justified to do so that the society can protect themselves.
Well, you also have notice and an opportunity to be heard.
Right, but I think this is a separate issue. I'm not even arguing procedural due process at all. So there are other times, like when this court issues attorney discipline. That is a compelling state interest to tell the society to stay away from this attorney or the bar, to know who they're dealing with. But in my case, also with the teacher who has been convicted of misconduct, there is a compelling state interest to tell the public that this person has been convicted of something, that they have received educator discipline. But when the person has been guilty of no misconduct, has been vindicated at every forum possible, there is no interest in the state sullying his name. And that is what we're here for today, is that the way that the Commonwealth interprets the statute does that.
So to follow up on what Justice Bronson just asked you, really what you're asking for is a complete and whole deletion of the record of a particular arrest, not putting it on the website that, hey, he was charged with these offenses and found not guilty.
Right. So in the court system,
I'm just wondering.
right, in the court system, it's already gone.
I'm not talking about protecting at this point because the bell's already been rung.
Correct.
To restore the reputational interest, what is it you're asking us to do?
I think it is still protecting because every time he applies for a job, they're required to look at that record. The employer looks at that record and sees that he was charged with these
So
offenses.
to that point, wouldn't you be better off saying charged with an offense, suspended, and found not guilty? Or do you want to just completely delete it off the record?
No, I want to completely delete it off the record because there is, in this court's jurisprudence as related to criminal expungements and mental health commitments and with PFAs, that you have held multiple times that just the record of that arrest or the PFA or that mental health commitment by itself is damaging to a reputation, even if later overturned, even if acquitted. There's no question that when someone is charged with such a crime, school districts will have a hard time hiring that person because of the public pressure and because they're risk adverse.
So, counsel, so are you saying that the Constitution guarantee of a right to reputation is triggered at every acquittal, so everyone's criminal record has to be expunged?
That is the law in this case, in this court's case in Commonwealth v. DM, if there is an acquittal. If there is a disposition less than an acquittal, then you apply the Wexler factors. But with acquittals, they all must be expunged. What this court has said is it's adjunct to due process. They haven't used the word substantive due process. They say there's a right adjunct to due process for acquittal. In case of acquittal for expungement. That is what would happen in DM. This court then applied that in the Wolf versus Beal decision to 302 mental health commitments. And then the court applied it again to PFAs. In both those cases, the court acknowledged that for mental health commitments, that carries a stigma. A record of a mental health commitment will carry a stigma that will go with someone regardless of whether or not it was eventually overturned. And what this court said is we need to do the same thing that we do in criminal expungements by wiping the record. Because the person deserves nothing less than when he entered the criminal justice system, entered the mental health system innocent, and then he can leave it as well innocent with no further marks. I think due process demands that.
Okay, thank you, Mr. Sturgeon. Let's hear from your co-counsel, Mr. McEwen.
Thank you, Your Honors. May it please the Court, my name is Richard McEwen, and I represent the petitioner R.W. The constitutional issues in this case that are being discussed and that were acknowledged in part by the Commonwealth Court are a direct result of the agency's misinterpretation and misapplication of the Educator Discipline Act. The Department and Commission erroneously insist that their interpretation is compelled by the statute. This approach is both factually inaccurate and misses the forest for the trees. The EDA can and should be read in a manner that avoids any constitutional harm to an educator. And I think some of the questions that were being raised can be addressed when you look at the process in Section 9B, which is titled Discipline for Criminal Offenses. This is where the immediate suspensions were issued under. The immediate suspension represents only the preliminary step of Section 9B's expedited adjudicated process. In response both to your question, Justice Mundy, and to your question, Justice Probson, the immediate suspension is based only on a criminal determination of probable cause rather than a preponderance of the evidence. And that is because Section 9B sets out a process for determining the suspension procedure. The first step is whether the criminal determination of probable cause. The immediate suspension, which is conditional and temporary, then issues. The fact-finding step is delegated to the criminal justice system by the statute. And the Commission's final adjudication cannot be made until the outcome of the criminal process is known. Depending on the outcome, the result is either revocation of the educator's certificate upon conviction or the lifting of the immediate suspension if the charges are resolved in the educator's favor, since there has been no finding of misconduct. Since the order lifting the immediate...
Could I stop you there?
Yes.
Does your argument and analysis make any difference if the adjudication was an acquittal versus a null pros?
I don't believe so. The statute refers to a right to lift the suspension when the charges were dismissed or otherwise removed, and I think that covers both circumstances. But Section 15C of the EDA, which is the expungement portion, states that where the Commission's adjudication finds no educator misconduct under the Act, the charges pertaining to the disciplinary proceeding shall be expunged. The final order lifting the educator's immediate suspension constitutes the true adjudication required by law that there has been no finding of misconduct. Consequently, the charges pertaining to the disciplinary proceeding, including the issuance of the immediate suspension, should be expunged. The Commission and the Department's failure to do so is contrary to law, and the Commonwealth Court's failure to order complete expungement was in error. The Department's contention that the preliminary determination that justifies an immediate suspension, that is a final adjudication of educator misconduct, is clearly erroneous. The immediate suspension order is just the preliminary step in the process. It is by necessity contingent on the outcome of the criminal proceedings. Thus, it cannot be a final order. Once in my client's case, the Butler County Court dismissed the criminal charges, the Commission adopted its finding of no misconduct by ordering the lifting of the suspension. The suspension wouldn't be lifted if there was any indication of misconduct. Therefore, the order lifting the suspension is the final order, and that should trigger expungement under the law. The Department erroneously claims that Section 15D requires it to maintain the public record of the educator's immediate suspension. However, that provision...
It's not arguing that the record hasn't been expunged. It's just arguing that it still has the right to keep the post on its website.
Right, but it is only authorized to keep posts on the website if they involve an adjudication imposing discipline. And here, the final adjudication did not impose discipline. It lifted the discipline. So our argument is that they are not authorized to continue to publish this once the charges are dismissed and there's a finding of no misconduct. Once the criminal process results in a determination in favor of the educator, either through the dismissal of the charges or acquittal, when remnants of what is designed to be a temporary conditional discipline remain on the public record permanently, the educator's constitutional rights are violated. In response to one of the other previous questions, another issue with how the Department and the Commission lift suspensions is that there is the initial immediate suspension. Whenever the criminal charges are dismissed, they post a separate listing that the suspension has been lifted. So in my client's case, for example, somebody reviewing the public database would think that he had a 1-year suspension. His immediate suspension took effect in February 2019, and the lifting of that suspension didn't occur till February 2020. And despite the fact that there's no finding of misconduct supporting that. And alternately, I think that was discussed a bit, the educator has a due process right to expungement independent of any statutory requirement. We cite several cases in our brief, including the Carlacci case, where it states that the court must balance the individual's right to be free from harm attendant to the maintenance of the arrest record against the Commonwealth's interest in preserving such records. Once the criminal charges against an educator are dismissed and expunged, the balancing considerations must change. Without any competent legal evidence to support an immediate suspension, an educator's liberty due process, and reputational rights take precedence, and the state no longer has any compelling interest in preventing or impeding the educator's continued employment. Thus, the imposition of continued sanctions against the educator's certificate and employment is not narrowly tailored to address the Commonwealth's interest in the safety and welfare of students. Thus, the educators have a right to expungement both under the statutory language of the EDA and due process. And we believe Commonwealth Court erred in not ordering complete expungement of the record. There is another statutory option to ameliorate the constitutional concerns, which was not considered by Commonwealth Court, although it was raised in our petition. As I mentioned, there's a provision that says that immediate suspensions must be lifted when the charges have been dismissed or otherwise removed. The word lift means to revoke or rescind. Lift has also been defined as to revoke by taking back. Revoke means to nullify by withdrawing, recalling, or reversing. Clearly, the legislature intended immediate suspensions resulting in dismissal of the charges or acquittal following trial to be considered void ab initio and rescinded in their entirety. Other language in the law confirms the legislature's intention. For example, in addition to lifting the suspension, the legislature also directs the Commission in Section 9B to reinstate the educator's certificate. In all other contexts under the school code, reinstatement reverts back to the initiation of the overturned action. There's no reason that a teacher certification matter should be handled differently. Similarly, Section 9124 of the Crimes Code only authorizes departments and agencies to revoke or suspend a professional certification when there has been a conviction for a felony or relevant misdemeanor. Moreover, expunged records cannot be considered a conviction that disqualifies a person from employment. Here, as I mentioned, there is in essence a de facto one-year suspension on the public record for my client, which is not based on any conviction. Furthermore, in the preamble to the Clean Slate Law, the legislature makes this statement of public policy. Individuals with charges not leading to convictions may be inherently harmed by the maintenance of that record and have a constitutional presumption of innocence. Logically, the legislature must have intended that this same public policy apply to Section 9B of the EDA, and this compels a determination that the lifting of immediate suspensions based solely on criminal allegations that do not result in conviction requires complete revocation and nullification from the date of their inception. Commonwealth Court failed to properly consider this issue or recognize the legislator's intention that unsupported immediate suspensions be considered void ab initio, pursuant to the public policy of the Commonwealth, as expressed in multiple laws. Thus, the Commonwealth Court's failure to order the complete lifting and reinstatement of these educator certificates and the failure to consider this issue independently in R.W.'s case constitutes error that the court should reverse.
Counsel, what if the criminal court refuses to expunge the charges? We've all seen situations where Commonwealth can't proceed, victim won't testify, Commonwealth null process the charges, defendant then files a petition for expungement of the record. Trial judge says, no, I'm not going to expunge the record. Pennsylvania State Police, the local law enforcement agency, opposes it. In that situation, do you still contend that we should issue an order to protect your client's reputation and expunge the suspension entirely under the Educator Discipline Act?
Yes, I do, because the basis of the immediate suspension is an accusation of a crime committed under Section 111E. So it's a heinous, serious crime. And so by continuing just to post that the person received an immediate suspension, even after eliminating the specific charges, that tells everyone in the education community that this person was charged with something very serious. And if those serious charges go away, there's still no basis for that immediate suspension. If they materialize later on, or even if they don't materialize, the department retains the ability to do their own independent investigation and file educator discipline charges under Section 9D of the Educator Discipline Act. So expunging that doesn't leave the person off the hook, if that's the court's concern. The department is still free to pursue disciplinary action against that individual.
Okay, let's hear from the department. Thank you.
Thank you.
Hi, good morning, Madam Chief Justice, and may it please the court. My name is Nadia Camille, and I serve as an assistant counsel with the Pennsylvania Department of Education. My co-counsel is Deputy Attorney General Anthony Kowalczyk. From the Office of Attorney General, we're here today representing the Department of Education and Professional Standards and Practices Commission. We are seeking affirmance of both decisions of the Commonwealth Court. And we're going to be similarly dividing up the argument as follows. I will be addressing argument on why the Commonwealth Court correctly determined that publication of the disciplinary orders and actions remain necessary and is required by the Act. And Attorney Kowalczyk will address the constitutional arguments posited by appellants, particularly that this publication does not violate either appellant's constitutional rights. And if the court does have case-specific questions, I was the attorney who handled the RW appeal, and Attorney Kowalczyk handled T.G.A. And there were some things that were raised in my respective colleagues, our respected and respective colleagues' arguments that I do want to address head-on. But just to give a little bit of background and to provide some clarification on the law, the department serves as prosecutor and the commission serves as adjudicator in these educator disciplinary matters, and both share in the important role of ensuring student safety and protection, maintaining the integrity of the teaching profession, and we do so by following and enforcing the Educator Discipline Act. And this allows for the imposition of professional discipline against a teacher who engages in professional misconduct as dictated by this system, and it also provides due process for the educator. Discipline can be imposed for a variety of reasons, and in this matter, as this court is well aware, the discipline of appellants were imposed pursuant to Section 9B(a)(1) of the Act. These individuals had their teaching certificates posed not only because they were charged with certain enumerated offenses in the public school code, but because they posed the requisite threat of harm to the health, safety, and welfare of students.
But counsel, none of that's in dispute. What's in dispute is what is your client's goal in continuing to stigmatize people against whom the charges have been dismissed? What is the goal? What is the legitimate goal of your client in doing so? Because that category of people against whom charges have been dismissed is not only these two people, but it's also people, could be them, could be others, against whom completely fabricated accusations have been made, and who are factually innocent and who will nonetheless carry the stigma for their entire lives. I want to know what your client's interest is in those scenarios.
Sure. So, well, first and foremost, when the department receives information, an educator misconduct complaint comes in on an educator who's charged with requisite offenses, which could trigger us to file for an immediate suspension. We take a look at the charges, we take a look at what the allegations are underlying those charges, and we make a determination as to whether we think this person poses a threat. But we still have to prove by preponderance of the evidence that the educator poses a threat at a hearing, and in neither of these cases was a hearing requested. They certainly have a right to have a hearing on whether or not they pose a threat. They could bring in outside witnesses. They could bring in somebody from a neighboring teacher across the hall.
Well, who would elect to try such a case when they're in criminal jeopardy? I can't imagine there would be anybody in criminal jeopardy who would put on an affirmative case in such a proceeding. Has that ever happened?
It certainly has. We have had hearings on this threat determination, and we're not asking the educator to get on and talk about what happened. We're not trying to prove what actually happened at this point. This is a mechanism in order to allow for the educator due process. They're given notice and an opportunity to be heard, and they're allowed to come in and say, hey, don't suspend my license at this point because I don't pose this requisite threat, and they're not required to testify, but we still have to show that they pose a threat. And the commission doesn't just rubber stamp these when we come in before them. They do make an independent examination as to whether these allegations warrant removal from the classroom at that time. Now, to answer your to go further into your question, Justice Weck, this end goal, so the educator does have the opportunity to get the suspension lifted if those charges are removed, and there's likewise notification of that showing that they're no longer associated with these charges.
Is that
but
true
this,
for sexual offenses?
if the educator is, let's say, without going into detail, but no, you understand what the underlying allegations were here. But if an educator is charged with institutional sexual assault related to allegations they had sex with a student, and the immediate suspension is warranted, once the charges have been dismissed, if the charges were dismissed or removed for any reason, the department is then, the commission would then lift the suspension and direct the department to lift the suspension.
Is it fair to say that you charged him, I believe you said on the record, 2070.9C(a)(1), immorality? Is that it?
That's a subsequent proceeding. That's a subsequent proceeding. So if the department still thinks that discipline is warranted, we're not prohibited from seeking professional discipline in these cases. And so in the one case, the educator subsequently surrendered his certificate, and then the other case, charges were brought forth under the immoralities. A surrender does constitute professional discipline under the Educator Discipline Act.
Counsel, you have Justice Weck, Justice Weck needs an answer to his question.
Yes,
you're kind of taking us around Robin Hood's barn here.
Sure.
The question is, after someone has had criminal charges, they've been found not guilty and therefore are innocent, presumed innocent, what interest does your client serve by keeping their history for the public to see?
Well, and that is the associated threat. That the threat finding is what we're putting out there, is that they were once disciplined because they were deemed to pose a threat.
Well,
and so that allows for.
That's where I'm going to have a question for you. This is an automatic suspension. This is a suspension driven by the fact that criminal charges were filed. There has been no adjudication of misconduct ever by your client, correct?
I had handled the RW case. Subsequently, he surrendered his certificate, but the immediate suspension process is considered an adjudication because
not of misconduct, though. It's an automatic suspension separately from an adjudication of misconduct. It's triggered by the charges existing, along with a finding that they pose a threat. Put away the charges. You cannot suspend. Posing a threat is not in and of itself misconduct that can be chargeable and lead to a license suspension by your client.
Under Section 9B, we would have to have the requisite offense in order for us to seek that suspension.
Right, but I'm saying let's put that aside. Is there anything under the code that says that you can suspend a licensee because they pose a potential public threat?
Well, if the department under Section 9C of the Act would file, we can ask for a threat finding, which would expedite the process. That's a separate process than Section 9B.
No, I'm saying is posing a threat an independent ground of misconduct? Independent.
It's not listed in 9C.
Correct. So what you have here is you have an automatic suspension triggered by a criminal finding, and your sole responsibility at that point in time to trigger the automatic suspension is a finding of a threat. Correct?
We would have to, yeah, along with the criminal charges.
Okay.
And
but that in and of itself, the criminal charge, the imposing of the suspension because of the criminal charge, and the finding of a threat is not the equivalent of finding that these teachers engaged in misconduct, correct?
Well, there's a finding that the educator was charged and that they pose a threat.
I agree with you. I'll concede that. Is there an adjudication of misconduct?
There is a final order, and the order imposes the suspension, and they are.
Is there an adjudication of misconduct under the code?
I would say that there is, because this is considered professional discipline under the Act, and it's subject to appeal. It's not confidential.
I understand that, but professional discipline is treated differently under the Act. It talks about professional discipline, but this code specifically says that if there's an adjudication finding no misconduct, not imposing discipline or not imposing discipline, finding no misconduct, you have to expunge the record. Your client never found that they engaged in misconduct. Your client imposed automatic discipline because the statute requires you to impose discipline under certain circumstances not related to misconduct. But there's never been a finding of misconduct by these teachers.
Respectfully, our position is that the misconduct occurred when they were suspended under Section 9B because they were charged and because they were deemed to pose that threat of harm.
Being posed a threat of harm is engaging in misconduct.
Yes, I mean, that's part of the misconduct, that's part of the analysis. And again, we have to, we still have a burden to prove in these, if there were a hearing in this case, or either of these cases, we still would have had to go in and show that they pose a threat. And in some cases, the commission determines that the threat isn't there. So they don't suspend. So the suspension still has an effect on them. It's their ability to teach. It's subject to appeal. It's public.
I'm not questioning whether you, and I don't think the council is questioning whether you had the authority to suspend them. I think everybody agrees that you did. The issue I have is from a statutory construction perspective. There is nothing in the code that authorizes you to keep a record open where there's been an adjudication of no misconduct. Where I'm struggling, and you're not really helping me very much, is there's a whole list of what educator misconduct is in the code. This provision that you suspended them on is something different. It's a threat protection for the public based on an allegation of criminal charges. It's not an adjudication of misconduct. At least I don't believe it is. And you're telling me you think it is. That simply by being charged criminally, and as a result of those criminal charges, a determination by your board that they pose a threat, that factual scenario equates to the educator engaging in misconduct.
We would say that that's because it does result in a final order. It does result in an appealable order, and it does it would go before the Commonwealth Court, and then they would make a determination whether we had substantial evidence to do that suspension. I mean, that's a final order that was imposed.
And what would the substantial evidence be? Just the mere arrest?
It could be a number of things. Typically, we will produce criminal documents, maybe somebody from a witness, maybe, but it just really depends on the situation. It's fact specific and depends on the totality of the circumstances.
Is it your view then that every single person who is a public educator who has ever been the subject of such allegations shall for all time be posted on your website?
In our view, or in the department's view, is that if the educator had received their due process and were able to request a hearing on that, and the commission required us to do the suspension, and then they subsequently have the suspension lifted, they have both up there. I mean, their remedy is to have the suspension lifted after they've been.
So suppose somebody on advice of counsel charged with serious crimes doesn't do your administrative thing, he's waiting for his criminal trial, and he's acquitted. He has no remedy. He will forever bear the mark of Cain, and every single school district searching for his history will see that mark of Cain for all time. That's your position?
And I just want to make sure that I understand this question, and I want to get back to your original question as well. We would only post them on the website if they were given, if we sought the immediate suspension. We don't automatically post every educator who's been charged with these crimes because we may not get to the immediate suspension process. So their
constitutional rights depend on your good decision making. In other words, there's no disincentive if you win this case for any crazy person anywhere to make accusations against public educators, because but for your good graces in your decision making, they will be posted for all time, no matter how insane the allegations are and how defamatory and wrong. Is that your position?
Well, I would say that the position is, I mean, there's a few, I want to take a step back because, typically we don't, in our process, I'm giving you like what we do from a process perspective is that, there is an independent determination usually made by somebody criminal in the criminal courts where the charges are held over for court. Will then seek the immediate suspension after that point. But whether or not we do have to make an evaluation as to whether or not we think that this person poses a threat.
Yeah, but oftentimes, and I would assume you'd have to agree with this, oftentimes the department simply satisfies its burden by admitting the criminal records and the charges and basically rests.
I would say that that's oftentimes what we do, and then the educator's given that opportunity
So all you have to do to shift the burden, at least in your administrative setting, is put forward the criminal charges.
That's oftentimes what we do. Again, it doesn't prohibit us from calling witnesses, which we have done in the past.
It's not a question of what's prohibited.
Yeah.
It's just the fact that oftentimes, probably more often than not, the department will simply admit the record of the criminal charges, the docket, and rest.
And there is an import of student safety here, which I think everybody can agree that the department has a responsibility to protect students.
That's why nobody here is challenging the suspension.
Right. But I think I do want to get into, and I think if I can get into the challenging of the suspension, because I do think that this is a challenging of the validity of the suspension.
Nobody questions that. You keep want to focus on, you continue to want to focus on the initial suspension, which is not at bar here. We're talking about the stigmatic residue that you insist on maintaining. And that is not only for the clients of these two lawyers, that's for all public educators in this Commonwealth who could be wrongfully accused, vindicated in criminal court, but will forever carry the stain that your client insists on maintaining on their website. And I'm looking for your explanation of how that comports with our Constitution.
Well, and I know that my colleague is going to get more into the constitutional argument, but I mean, we have an opportunity to protect students, and that if somebody's been deemed a threat in this independent process, we do put that information out there. Now, there's a difference between the website and also, like, I understand the website concern that's been raised by Justice Wecht, but also the question as to, is this a complete and total obliteration of the record of the suspension? Because we do have situations where an educator, is there a requirement now to expunge this fully from the records of the department, and that if we ever received a right to know law request on a valid suspension, are we not supposed to comply? Is the educator no longer required to put this on an application for employment that they were suspended, or even an application for licensure with BPOA? They want to go get their realtor license, and they had this immediate suspension, and now they're trying to seek something else. So if we're required to expunge this, then we're essentially hiding that information.
Well, but the statute already requires you to expunge.
Respectfully, we think that this is a disciplinary action that would require to be posted under Section 15D.
I know, but you're acting like expungement's this terrible thing. But right now, if you filed actual misconduct charges against let's say after these criminal charges were null prost or found not guilty, sure, you went ahead and pursued morality administrative charges against these educators. And you filed the charge, and if some school district had searched their name while it was pending, they would see there's charges pending, right?
They would see that there was a disciplinary action taken, and then the discipline had been lifted.
I'm talking about starting with the morality part. Put aside the criminal side. You would file new charges. Mm-hmm. You'd lift the suspension. You'd file new charges on some actual misconduct, specific misconduct charge, probably morality. Let's just say that happens. And then, so if while that administrative proceeding is pending, they apply for a job somewhere, that school district they apply for could look up and see that there's a pending charge of morality, correct?
No, that's not correct, because it's confidential if and until public discipline is imposed.
So, counsel, do I understand you to say, if in fact through 9B you request a hearing, and through, what did you say, 15D, the educator facing criminal charges chooses his Fifth Amendment right to remain silent, that is the implicit reference is negative, such that finding, despite a subsequent criminal trial and not guilty and further expungement, that requires his charges to remain on a public internet based upon your administrative hearing.
Well, the Commonwealth Court did, in this decision, remand to the department and to the commission to remove reference to the specific criminal charges. So those have been removed. Those have been taken off of the internet.
That's not exactly true. What the department did is reference the entirety of the statute that lists a host of horrendous crimes that are implicated. It made it worse, not better.
At this point, we've now listed
that's what the department
basis
did.
for the discipline was the the 9BA1. I mean, that's the basis for the discipline. I mean, we're not trying to rewrite history here. These individuals were professionally disciplined pursuant to Section 9BA1 of the Act, and that's part of their disciplinary history with the department, and they have every opportunity to explain that, you know,
This was predicated on conduct for which they were then tried and acquitted, or null prost, right? Isn't that right?
It was predicated also on the threat, and they did not challenge that.
Suppose after their acquittals, the dismissal of their criminal charges, your client was sitting there thinking, you know what, these guys are no good, they were acquitted, but we want to bring charges under the Educator Discipline Act. If for whatever reason, you could have done that, and then if that was founded, you could put that up on your website. But that's not what you did here. You insisted on maintaining the mark of Cain from their criminal charges on your website, because that was the basis for your initial misconduct imposition.
And to clarify, in the subsequent case, RW was professionally disciplined. He did surrender. That is also up on the department's website with the reasoning with agreed to language as to why he was suspended or surrendered.
Okay, thank you. Let's hear from Mr. Kowalczyk.
Good morning, Madam Chief Justice. My name is Anthony Kowalczyk. I'm a Deputy Attorney General for the Commonwealth of Pennsylvania, and I represent the Department and the Commission in the T.G.A. matter. I'm not going to repeat what Ms. Camille covered. I'm going to try to move to address the constitutional issues, particularly under this Court's cases, and address any questions that the Court may have. I think it's very important to point out initially that I've heard some fatal concessions from the appellants, and I've read fatal concessions in their briefs. And I think Justice Brobson's question alluded to this earlier. This Court's decisions recognize a right to reputation in the procedural due process context and in a context in which I'll refer to as a favorable termination context. And I'm going to briefly explain what I mean by that. In the grand jury cases, the 2018 cases involving the priests, and I read the one you issued a couple weeks ago in the 30th County grand jury case, those cases deal with situations where individuals are entitled to protect their reputations, are entitled to due process under the factors articulated in Matthews versus Eldridge and in this Court's subsequent Bundy decision, and situations where individuals who are going to be defamed in grand jury reports have a right under the state constitution to refute those or have them expunged or redacted or suppressed or sealed in some way to protect their reputations. We don't have that situation here because they are conceding that they're, number one, that the suspensions in RW and T.G.A. were valid. They're not questioning the validity of the suspensions, and they're not contending that there was any due process violation in the way that the suspensions were imposed. Those concessions are fatal because under this Court, I heard them refer to some of this Court's prior decisions in the civil commitment PFA context. Wolf versus Beal, 1978, does not support the position that they're taking. Wolf involved an invalid and unlawful civil commitment. The civil commitment was invalid at its inception, and it was declared illegal. And when this Court ordered the destruction of the records resulting from the illegal hospitalization, it was premised on a determination that there never was at any point a valid civil commitment. And then in the Carlacci case in 2002, that's the PFA case that they were referring to. That PFA was issued as a result of an ex parte proceeding, and there was a stipulation approved by the trial court in that case declaring the PFA void ab initio, which means that there never was a valid PFA at any point. That was a stipulation signed by the parties, approved by the court. And this Court ordered the destruction to protect the reputation of the individual who had been subjected to the PFA, Counsel, because there never was a PFA.
Let me ask you, since you talked about the priest cases, would you agree that the educators here have an interest in a constitutional interest in their reputation?
In protecting their reputation?
Yeah, would you
Well,
agree with that?
I believe everybody does. I mean, under Article 1, Section 1, I don't really
Fair
think
enough.
that's in dispute.
And so, on a countervailing basis, what interest does your client have in sullying that right of theirs, impairing that right of theirs in any way once they have been acquitted?
Well, they've been acquitted of the criminal charges, but there was still a finding that they posed a threat.
Were those
There-
criminal charges not premised upon the pendency of the misconduct allegation?
Of the underlying misconduct?
The threat finding. Is that right?
Well, the criminal charges in the T.G.A. case, okay, there's an important point that I think that needs to be called to the court's attention as well, particularly with regard to T.G.A. There actually is a way that T.G.A. could have avoided the suspension without even challenging it in an administrative proceeding by submitting an affidavit.
By submitting an affidavit while he was being prosecuted criminally.
The affidavit only had to say that he wouldn't be a teacher, that he
It
wouldn't
doesn't
teach.
Well,
That he wouldn't teach. It didn't have to admit or acknowledge anything. That option wouldn't have been available to RW because RW's conduct involved, I believe, students, whereas TGA's didn't, but that option was available. So the ability to challenge the suspension, to avoid the suspension was there, at least in the TGA case, because his interaction involved an adult woman, and he never offered to submit the affidavit, and we point that out in our brief. That option was never pursued.
let me just ask you one more thing.
Yes.
on that. Counsel, would it be a more appropriate avenue for your client to comport with our Constitution's Article 1, Section 1, right to reputation to post everything, whatever, on the website while the criminal matter's pending, as nobody's challenging here. And in the event of a dismissal or a null pros, and the crime is then a nullity, evaluating whether there is some misconduct your client wants to allege, and then seek to litigate that, and if you prevail, put it back up on your website. Why would that not be the way to comply with the right to reputation rather than having the scenario we have now, which from my understanding means that any public educator in this Commonwealth who is ever accused, and there are many wrongful accusations that happen, will forever bear this mark of Cain. Why do you want the second scenario rather than the first?
Well, I think it's important to point out that the department and the commission are following the legislature's directive, okay? And the Commonwealth Court articulates this very well in its opinion, the distinction between expunge and lift. So the legislature wrote the law, the department and the commission are following the statute as written. Okay, now with respect to the second part of your question, as I understand it, okay, taking the suspension down under these circumstances, as the law is written now, would not comport with the statute. So it's not a situation where, for instance, as the T.G.A. brief, for instance, alleges there's egregious conscience-shocking conduct, relying on County of Sacramento versus Lewis. That applies to executive action. That doesn't apply to legislative action. When the legislative directive is simply being followed, the executive does not engage in any kind of conscience-shocking conduct.
They've offered a statutory construction argument to avoid the constitutionality issue, and the fact of the matter is there has been no adjudication of misconduct by these teachers. There's been an adjudication imposing discipline, because the General Assembly says you have to impose discipline when there are criminal charges if you make a finding of threat, but again, I mean, that the threat is usually based off the charges alone. So their suspension is on the record based on essentially an automatic suspension for criminal charges. They have a period of suspension between the time it's imposed and the time it's lifted. And they have been denied forever the opportunity to get an adjudication of no misconduct.
I don't think that they're denied the option of getting an adjudication of no misconduct. There's nothing in the law that prohibits an individual from arguing that he or she is not a threat because the alleged misconduct never occurred is completely fabricated.
But again,
they may not want to proceed down that road, but that option's still there.
But there was, and again, I want to give you an opportunity to answer the question that I asked your co-counsel. Where is the adjudication of misconduct here? There's an adjudication essentially confirming criminal charges were filed, which is really not an adjudication at all. And they kind of waived it, but let's assume it even went to a hearing. Most times the Commonwealth satisfies its burden with the criminal record and charges alone and sort of rests. They don't bring in investigators, they don't bring in witnesses, they don't do anything like that. So what is the actual what provision of the Educator Discipline Act, what list of misconduct led to the suspension in this case?
To the suspension?
The actual what did they do that caused the suspension?
Well, I think we're talking about two different provisions here, because there's one provision that talks about expunging the record when there's been a finding of no adjudication of misconduct. And I think you're referring to, I believe I'm going by memory here, section 15C. And
which
that
is in the same section.
And that refers to the charges that were brought against T.G.A. after the acquittal. There was an adjudication of no misconduct, or at least no finding of misconduct under a preponderance standard. And the record of that disciplinary proceeding was, in fact, expunged as the statute requires. But the provision I'm talking about requires the posting of adjudications imposing discipline. That's a separate provision.
I know what you're talking about.
Yeah, that's what I'm...
My point is, by you handling this the way that you're handling it under the statute, it ignores the fact that the statute provides for an expungement remedy in the event of a finding of an adjudication of no misconduct. Mm-hmm. You, by having the suspension on the record and it lifting, and not giving the educator an opportunity to get an adjudication of no misconduct, you're preventing the opportunity for the expungement.
I don't believe that they're prohibited from establishing.
Even if they would have challenged at the hearing, that decision. Let's say they put on a whole bunch of community evidence about their reputation. They put a whole bunch of character evidence about their character. Let's say they even did, and they didn't testify because they were in jeopardy, but they put a whole bunch of stuff on. Even if you found they posed a threat, that is not a finding of misconduct. It's a finding of threat.
It is not, Justice Robson, but I also think that it is possible that somebody could establish that, they don't have to establish anything. The department has to establish
that they are a threat. But in the context of that adjudication, can the board adjudicate no misconduct?
I believe that a finding of no threat can be based on a finding that the charges are fabricated and that there's no reason for an immediate suspension.
Are you suggesting that your commission has the authority to find that charges are fabricated?
No. What I'm saying is, though, they make a separate determination as to whether an individual poses a threat.
Right.
And I don't think there's any limit as to what the basis can be.
Has the board ever adjudicated criminal charges in the context of this statute?
I don't know whether they have or not. I'm not as familiar as Ms. Camille is with how things typically go before the board, but the statute, as it reads, does not, in my view, preclude a determination that someone is not a threat because the charges
I'm sure the Attorney General's or the District Attorney's Office in Pennsylvania would like to know that the board is deciding whether charges are fabricated or not.
But it's the Commission's determination to determine whether someone poses a threat. And somebody could, it's possible that somebody could be accused of some kind of criminal misconduct and wrongdoing and not pose a threat. And in that instance, the Commission could make a determination that this person does not pose a threat, even, without, saying whether there was misconduct or not. The Commission votes that they're not a threat. We don't know what that's based on.
Is that a finding of no misconduct?
Not necessarily, but somebody who's charged has an opportunity, in the case of T.G.A., for instance, to submit an affidavit, not go through the process at all, not get the suspension if the Commission accepts the affidavit. And then if they move forward, and the department moves forward under the preponderance standard and has to establish that this person is in fact a threat, the finding of threat, no threat, could be based on any of a number of factors. It could be based on a view of a commissioner that the person probably didn't commit this act, or it could be based on the fact that even if they did, they don't pose a threat to the students or someone in the school environment. Now, I acknowledge it doesn't result in a finding of no misconduct, but it is still an adjudication imposing discipline for statutory purposes, and that's all that matters. It is a valid suspension.
Counsel,
And that's, I'm sorry, yeah, go
can
ahead.
I just make sure I understand this? Despite the acquittal, despite an expungement, it's the department's position that it is legitimate to keep the suspension posted because there was a finding of a threat?
A finding of a threat.
Period.
Yeah, an adjudication
period.
imposing discipline.
Well, period. So it's freestanding in your mind. This finding that the educator was a threat is freestanding from the charges upon which the suspension had to be entered.
That's correct. We know it's a freestanding determination because it can be appealed. It can be immediately appealed to the Commonwealth Court.
So a criminal defendant has to appear before the commission in some way, shape, or form and present evidence with these criminal charges pending in order to establish that they are not a threat.
I don't know that they have to present evidence necessarily.
They have to do
They don't have to
something.
testify.
They have to do something. I mean, otherwise, I mean, what, you just show up, say nothing, do nothing?
Well, they would have to, the department acts as the prosecutor and has to establish by a preponderance of the evidence that the charged educator poses a threat to either students or someone in the school environment. Okay, that the burden of proof lies with the department, and the
Correct.
commissioner
And then-
acts as the
and
adjudicator and
once
votes
they
on
put in
it.
their evidence, at that juncture, the burden shifts to an educator who is also a criminal defendant to come forward with evidence. I mean, who would do that? Who would do that when you have criminal charges pending against you? I mean, even the affidavit that you mentioned earlier could be used against the criminal defendant.
I don't know about, I'm sorry, go
Somebody
ahead.
wants to have a PCRA down the line.
The affidavit would simply establish that they're not going to teach while the criminal charges are pending. I don't know that that would be used, could be used against them in any meaningful way. But
Well, you just said any meaningful way. I mean, a prosecutor might think there's something very meaningful about the fact that, isn't it true, you've given up your ability to teach? I mean, who would do that? I mean, I just can't, I can't imagine a criminal defense attorney who would allow their client to testify to present even that evidence in this context. So there's really no way for an educator to avoid this stain on their record in perpetuity unless they take a shot at defending while criminal charges are pending against them. That seems like an incredibly ridiculous proposition to a defendant who may go to jail.
well, I think there are different ways it can be contested. They don't necessarily have to testify, although they can. They don't have to testify. The evidence could be challenged that they pose a threat. There could be arguments made that they're not a threat because the nature of the underlying criminal charges do not involve students, which of course was the case with T.G.A.
But counsel, with all due respect, Justice Robson, who sat on Commonwealth Court, indicated that the routine would be mark and move the criminal indictment into the record and rest. How do you respond to a record without getting to
The merits.
the body? Yeah, and then by submitting, as Justice McCaffrey indicated, by submitting a letter saying I waive and I agree to be suspended from my education, will be deemed, if I'm the prosecutor, as an admission of guilt.
Well, wait. The affidavit wouldn't necessarily. It would. The affidavit states that the individual's not going to teach, and then no suspension is
And if I'm the
imposed. So then there wouldn't be a record of the
But if I'm a
suspension going
prosecutor,
forward.
I'm going to use that document and introduce it as evidence.
At the criminal trial, it's consciousness of guilt, isn't it?
Well,
So what you're really doing is saying you want to have your cake and eat it too. Despite the fact that your statute reads that if the educator does not challenge this, that they are forever held to the allegation on your internet, despite being proved beyond a reasonable doubt that they are not guilty of the offense for which you're arguing makes in danger.
They're not, the posting of the suspension does not establish that they did in fact commit misconduct before. It simply establishes the fact that they were suspended. It's a simple
So
fact.
if you own a bank, are you going to hire somebody that's been arrested for stealing from a bank?
If I were the employee, I probably would be inclined not to if I believed that the charges were true. If the individual was acquitted and exonerated, I would probably want to look into it further.
Think like a school board member. Think like a school board member charged with the safety and welfare of children. And you're telling this court that those school board members are going to approve the hiring of somebody who's bearing that mark of Cain. Wouldn't it be much more likely that that person would never even get to the point of being submitted to the board for approval?
Well, I don't know that that's necessarily the case, because the lifting of the suspension indicates that the individual was exonerated, was acquitted.
Does it say that on the?
No, it says it was lifted. And
a suspension could be lifted because the period of suspension has been satisfied.
Or something else could have failed in the meantime. It certainly doesn't signal that these people have been found not guilty, or it certainly doesn't amount to the same thing as not having the thing on your website to begin with.
And if it's lifted, doesn't that also mean that the aspect of that entry that they were found to be a threat is also lifted?
It's yeah, the suspension is what's lifted. Now,
but see, you can't cut it that finely. I mean, if in fact, in its entirety, everything attendant to that suspension is lifted, all of the underlying predicates are lifted, then it shouldn't be there.
Well,
including this notion that somehow they were found to be a threat.
I think that here's where the distinction lies. It wouldn't be there under this court's case law if it's invalidated. If there is a determination made that there was no valid suspension, they're conceding the suspensions were valid. So we're not in Wolf v. Veal territory with the unlawful commitment, Carlacci territory with the void ab initio PFA. We're dealing with valid suspensions.
But this is even worse. Isn't this even worse? A valid suspension that then was revealed to be invalid because the charges were dismissed or he was found not guilty.
It's not invalid. Okay, and that's an important distinction. It's a valid suspension that was imposed based on a finding of a threat, and because of the criminal acquittal, the suspension was lifted.
You keep focusing on this threat finding. Mm-hmm. The suspension is only good, valid, because charges were pending and there was a threat.
And there was a threat.
In the absence of both, the suspension goes away. It was invalid.
If the suspension is lifted, okay, it's not invalidated, it's simply lifted upon acquittal, and if there's a conviction, then they can go to revoke. But the suspension is in place in the interim, and it's valid. But in that
scenario, counsel, in that scenario, what would prevent your client from following acquittals, then determining that, in fact, you want to insist on going forward because you believe under a civil standard there's proof of misconduct and this person needs to be stigmatized on your website and the world needs to know about it. So at the back end, after the acquittals, why don't you have ample opportunity to do what you think is necessary from the departmental standard to safeguard the children, rather than doing what you're doing here, which is maintaining the mark of Cain, notwithstanding the acquittals?
Because the statute specifically requires the posting of all adjudications imposing discipline except private reprimands. So that includes suspensions. Now, private reprimands are specifically excluded from the categories of discipline that must be posted. So when the General Assembly wrote the law and they specify you don't post the private reprimand, but you post the other adjudications imposing discipline, that would include the suspension.
Counsel?
So, yes,
We're going to sort this out.
Okay.
At this time, I'm going to bring it to a merciful
Okay.
end. And I appreciate all of your arguments, and we're going to have a lunch break, Mr. Minner, till 1 o'clock.
thank you, Ron.
good afternoon. The crowd is thinning. Mr. Minner, would you call the next case?
Better Best Ventures LLC et al. Versus Pennsylvania Gaming Control Board. Representing the board, Mr. Daniel Straczynski. Representing Better Best, Ms. Kelly Young.
In this appeal by allowance, we are asked to determine the level of deference which should be afforded to the Gaming Control Board's decision to deny an application for a video gaming terminal license on the basis of its determination that the applicant lacked the requisite good character, honesty, and integrity for holding such a license pursuant to the Video Gaming Act. Please proceed.
Thank you, Your Honor. Good afternoon, Chief Justice Todd, members of the court, and may it please the court. My name is Dan Straczynski, and I represent the Pennsylvania Gaming Control Board, and we're asking this court to reverse the Commonwealth Court's order and opinion and uphold the board's licensing decision. This matter concerns the board's application of a licensing standard that requires applicants to demonstrate good character, honesty, and integrity. As the court can tell from reading the briefs.
Could you speak up a little, counsel?
I'm sorry. As the court can tell from reading the briefs, the parties essentially agree that the board's decision should be subject to a deferential standard of review on appeal. I think the disagreement stems from whether or not the board's decision actually survives when that type of review is applied to it. So unless the court has questions on other issues, I'd like to begin by explaining why the board's decision should survive under that type of review. And quite simply, it should survive because it was a rational decision that was logically based on evidence in the record, not on any type of improper factor or on a whim. And specifically, the evidence showed that the applicants are in an industry that causes substantial public problems.
Well, that's really, I'm glad you got right to the nub of it, because it seems to me there's like a category error here, or there's like your position is categorical. It's not particularized. So for you to win, we need to agree with you that any person engaged in skill games is of bad character, dishonesty, and lack of integrity. And the problem now, if this was the days of the old, what was it called, the Crimes Commission or whatever it was called, and there was a lengthy report, and it said these particular folks are engaged in nefarious activities. Okay, that's one thing. But here, as I understand it, your position is that anybody engaged in the skill games industry, as a matter of law, lacks character, honesty, and integrity, and that seems to me deeply problematic. You want us to rubber stamp a categorical view that you have about that industry, and the thing about it that is suspect to me, beyond the broad categorical nature of it, is it seems to me that you basically want to stiff arm this group on anti-competitive grounds. It's just the whole thing doesn't smell right to me, and I wonder if you could react to what I've just put to you.
Sure. No, I understand those concerns. Let me walk you through the way the board made its decision. It essentially, I don't think this is a categorical decision. I think the board weighed the evidence that was before it, and the evidence that was before it, specifically the testimony from the House Gaming Oversight Committee by Major Miller of the Pennsylvania State Police and Mr. Svitko, the director of the Pennsylvania Lottery. The board weighed that evidence and concluded that skill games present problems for the public, to the public specifically, and this is all in that testimony, that they're unregulated, they lack strict controls and regulations that prevent persons prone to compulsive and problem gambling and underage individuals, preventing those individuals from using those machines.
But how does that address Justice Weck's categorical question? Was there any evidence that the individual petitioners or appellees here engaged in any of that nefarious activity, that they that their skill games were being used by minors, that they were programming the machines in a way that was unsafe or unclear or fraudulent. Any specific reference into the way that they were operating their skill games?
No, there wasn't.
Okay.
But
So again, so it goes back to Justice Sweat's question, which is, you're basically saying anybody that's connected with the skill games lacks good character, honesty, and integrity.
So in this specific situation, the evidence showed that the applicants distribute skill games through companies that they own, and the evidence showed that skill games cause these problems for the public. But I think the crux of the board's concern was the lack of control and regulation. And I think that's part of the problem. We don't know what the operators of these.
But see, the legislature, it seems to me, you're in doing so, you're doing what the legislature has so far declined to do. And I know there are efforts in this regard. It's perfectly fine if the legislature wants to say we ban skill games, right? But having failed in that effort, the lottery or these other folks who don't want these skill games to compete with their interests, they can't use you folks, it seems to me, as a stalking horse to achieve through some fig leaf, not a fig leaf, some claim about character and honesty and integrity, which is not supported with respect to these applicants, instead of going the legislative route and proving their case to the General Assembly and getting the law passed banning these folks. Which, again, you could do that, but having failed to do that, this seems to me to be a bit of a subterfuge, using character, honesty, and integrity to ban a whole category. It's not like Teitelbaum and Brazetti were shown to be, mobbed up or the organized crime folks that this statute was asking you to screen out. That's not what you did here. You instead took a whole category and just honesty and integrity. It's just a really poor fit. I'm still not seeing the fit. So
the board's decision wasn't based on any type of policy. It wasn't a policy decision on behalf of the board. I understand that there is an ongoing policy debate surrounding skill games going on in the Commonwealth right now, and the board can't avoid that. But the board's decision wasn't based solely on its policy concerns or its view on the way that debate should turn out or how the legislature should treat skill games. It was based on the evidence in the record. It was based on the evidence, specifically the testimony from the House Gaming Oversight Committee, which the applicant stipulated to.
Well, what specific testimony? I mean, don't take this the wrong way, but I'm Irish. I know a bunch of bar owners. Couldn't you say the same thing for bar owners? We don't like the fact that these people own bars or any other category. Is there something specific in the record? Because it seems to me that the standard we're going to have to employ at some point is an abuse of discretion standard. What specific testimony in the record can you point to show us that this was based upon something other than the fact that these people just engage in skill games and that the board doesn't like skill games?
Well, I think the board's analysis of Major Miller's and Mr. Sfitko's testimony, I think, is what the board's decision was based on. I don't believe it was based on the board simply not liking the skill games industry. And I think that's reflective in the adjudication that the board issued. The board discussed, it discussed that testimony, gave it the weight that it felt that it deserved. And
what testimony?
The testimony from Major Miller of the Pennsylvania State.
What testimony? I know whose testimony. Okay. Tell me what testimony you're pointing to that should lead us to a deferential standard and say, the board got it right.
So Major Miller testified about the problems associated with skill games in general, and specifically that they're unregulated, they lack strict controls and regulations that prevent minors and persons prone to compulsive gambling from using those machines. They lack set payout requirements. They place stress on law enforcement in combating illegal and problem gambling.
Well, did he testify that the skill games that are run by these individuals are being exposed to minors, that they're not paying out correctly, that there's anything about the way that they're operating their skill games, specifically that questions their character, morality, and integrity?
Admittedly, it wasn't specific to these specific.
Right. Well, see, that's the point. It's a thought. Like that's the disconnect. You have testimony that was given to the lawmakers. It didn't get the result you or whoever's lobbying you, I don't mean you personally, I mean your board, that your board or whoever lobbies your board from the lottery or from, you know, the casino, whatever it is, that didn't get the result in the legislature they wanted. So the board carrying the water for whoever that is to achieve through this integrity, honesty, integrity mantra, something that was not achieved legislatively. And that is something that Teitelbaum and what's Brazetti, they're then suffering a categorical judgment by your board that's supposed to be individualized. And so I'm still not getting how you can ask us to apply that template.
Well, I think it's the fact that they distribute skill games and skill games cause problems for the public. That's the connection that the board made. I understand that there was no testimony about the operators of the games that the applicants distribute to, you know, not taking steps to prevent minors and persons prone to compulsive problem gambling from using those machines. But I think part of the problem is we don't know what the operators are doing.
Well, you could have found out, though. You could have found out. I mean, there's the investigator. You have the whole Bureau of Investigations and Enforcement that can do an investigation to determine how they're operating these skill games. And you know, Justice McCaffrey asked you a really great point. You can find a ton of public testimony about the harms of alcohol and nuisance bars and things like that associated with, you know, the ills of children and, you know, speakeasies or what have you. But you're not categorically barring bar owners because of those risks from having licenses, or beer distributors for that matter. I mean, that's you know, I kind of am where Justice Wecht is. I'm waiting to hear how you can say some specific applicant lacks the character, integrity, and honesty based on the fact that they're in an industry that the General Assembly has not seen fit to regulate.
I think it's sufficient. Our position is that it's sufficient to say that because they distribute skill games and skill games cause problems for the public.
What about bar owners or tavern owners or someone that has an ownership interest in a tavern or a beer distributor or, you know, you can't say liquor store because those are owned by the state.
Candy stores. How
about CBD oil or you know, medical marijuana facilities? You know, I mean, we could put a whole bunch of list of things that people could find testimony in the legislature about the moral questionable practice. How far does this principle go that an otherwise lawful activity that the board determines to be morally bankrupt, you know, can be used to deny an individual license based on their character?
I guess I disagree that it's a categorical decision on behalf of the board. I think the board weighed the positive and the negative character evidence that was available to it and made factual findings relative to positive character evidence. It weighed that evidence, but decided that the applicant's contributions to the problems associated with skill games.
But they didn't contribute to the problems of skill games. They're part of the industry. There's no evidence that they contributed to the problem of skill games.
So
there's no evidence that minors or anything like that. There were any complaints about you know civil complaints or criminal complaints or anything like that. There's no evidence they contributed to anything.
You didn't even have a statewide court adjudication. Not that this would have sufficed, but suppose there had been a universal judicial adjudication somehow that these skill games were just no darn good. I don't know how that would have arisen, but you didn't even have that. You had the Beaver County decision that went the other way at the time, right? So, and you have, as Justice Brobson indicated, a very robust investigatory staff, as I understand, with lots of well-qualified law enforcement professionals, many retired state troopers or other qualified people. And none of those folks came up with any dirt, so to speak, on these particular applicants. So you're left with this categorical assessment which did not carry the day in the legislature. And I'm still not seeing how you can get us to validate that.
So, again, I think my position is this wasn't a categorical decision on behalf of the board. It weighed the positive and negative character evidence that was before it and ultimately decided that the applicant's participation in the skill games industry and the problems that they contribute to outweighs any positive character evidence.
Counsel, it wasn't character evidence about any of these individuals. It was the quote-unquote character evidence about the industry. It had nothing to do with the evidence that you're talking about, the testimony that you're talking about, was the alleged evils of this unregulated activity.
Which is
Had
categorical.
nothing to do with these particular individuals. That's what your evidence, the evidence was about the industry, period. I mean, that's
Right.
essentially what the board held. And the Commonwealth Court said that's insufficient to fulfill the character, honesty, and integrity analysis necessary for the statute. I mean, there was nothing about these particular applicants.
No, I understand that, but again, I think our position is that their participation in this industry that has all these problems is sufficient to
But this industry is lawful, as we sit here today. So you're being the moral police by indicating that the applicant's involvement in a lawful industry is a negative reflection of their character. Under the standard of law, how do we not find that as purely a purely arbitrary execution of your duties?
So I don't believe it was an arbitrary decision. I think the board.
But it's legal. So what is legal? Because someone or your board believes that it may prosper or promote bad behavior. That's a character flaw, despite its legality, going back to the tavern owner and the CBD.
So I don't think the legality is the end of the question, and that there can be conduct that just based on the plain language understanding of good character, honesty, integrity. There can be activity that is both reflective of bad character, but is still legal. So I don't believe those two concepts are mutually exclusive. And I think that's essentially what the board concluded here. It essentially said that.
So let's drill down. So that is the overarching concern of the board. Yet, as Justice Brobson brought forth, there's no evidence of these organizations providing or doing anything that's reflective of your overarching concern. Why should we accept that?
So I think if we're analyzing the Commonwealth Court's opinion here, I think, or if we're applying an abuse of discretion standard here, I think we look at whether or not it's, like you said, arbitrary. The board's decision was arbitrary, capricious. I would push back on the conclusion that the board's decision was arbitrary or capricious. It was rationally based on evidence in the record, which showed that skill games present these problems for the public, and the applicants contribute to those problems by distributing those games. So I think it does survive.
Where's the evidence that they contributed to the problems by distributing those games?
I mean, there isn't any evidence that the operators of the games that they distribute to, are specifically, allowing minors to use the games or.
Yeah. So, look, I mean, you're sticking by your guns. I give you a lot of credit for sticking by. But we put on our best robes. We have to ask you the questions. To go back to the categorical thing, because you do seem to not want to concede that it's categorical. So I'll ask you a question this way. In the board's view, can anyone who distributes skill games in Pennsylvania get a license under the Gaming Act?
I'm hesitant to prejudge the issue on behalf of the board. I think the board would weigh any positive or negative character evidence and consider that factor in making its decision. But
as a result of this adjudication that you made with regard to this applicant, what evidence were they missing? Even though it's your burden to prove that they lacked good moral character, but what evidence were they missing that would have tilted somehow? I mean, if they came forward and said, we have all these robust protections to ensure that our machines are not given to minors, I mean, did they have to do that?
I think probably, just based on reading
even though it's your burden.
Well, before the board, I mean, the statute places the board on the applicants to demonstrate by clear and convincing evidence that they have good character, honesty, and integrity.
Right.
So, obviously, I think that would help. I think obviously that would alleviate a lot of the board's concerns.
You see nothing in your adjudication or your argument today that forestalls an individualized standard for someone who nonetheless distributed skill games.
Exactly, Justice Brobson. I think that's our position.
But then you have to, if you're answering Justice Brobson that way, then you have to also be able to tell us what these folks were lacking. I mean, they cooperated, and I didn't see anything in the record. Maybe I missed it about, you know, this one is tied to this organized crime family, or this one has a rap sheet, or there's nothing like that with these applicants. And so again, it sure looks categorical, and it raises the suspicion that this is anti-competitive, or that it's a concern that they're not generating taxes for the Commonwealth. But those, you see, those kind of concerns are legitimate concerns for the legislature, not for your board. Your board is not empowered to legislate broad categories. The folks downstairs are. So I still don't see what you're telling us about these folks failing the standards.
I think the board weighed the evidence that was before it. I think there could be a situation where somebody who distributes skill games possibly just, I don't think that this adjudication necessarily just automatically prohibits somebody from demonstrating that they have good character in spite of their distribution of skill games. The board in any situation is going to have to weigh the positive and character evidence that's before it, and that's what the board did here. It weighed the positive character evidence. It considered the fact that these games at the time were potentially legal, and it made findings to that respect. It made findings based on the Beaver County case and the Pennsylvania case before the Commonwealth Court. But it decided that the potential legality of skill games was not outweighed by the problems associated with it. And any character determination the board makes, it has to weigh it's sort of like a totality of circumstances test, as to weigh the positive character evidence against the negative character evidence. And I think the takeaway from the board's adjudication is that it believes distribution of skill games is a negative character trait. But I don't think we can say from looking at this adjudication that necessarily prohibits all potential applicants who distribute skill games from receiving a license. So that's I think where my pushback is on the claim that it's a categorical decision. I don't think it is. I think it's the board's using its best judgment, weighing the positive character evidence, positive and negative character evidence that was before it when it made its decision.
My question stems likely from my unfamiliarity with this line of business, but how can you infer a negative personal characteristic from the nature of the skill games? You just tied those two together, and I'm really not following you.
Sure. So under the Video Gaming Act, I believe it's Section 3502B, the board is required to look at it's a broad examination. It has to look at information pertaining to family, habits, association, reputation, criminal history, background, but also business activities and financial affairs and business and personal associates. I think the board here looked at the applicants, specifically Mr. Teitelbaum and the Brizzettis, business activities, and determined that they distribute skill games. That's part of their business activities. That's part of the character assessment that the board is required to conduct when it reviews an application.
But it's a legal business activity. They're engaged in a legal business activity. How do you infer a negative from that? How does that adversely affect on their character, honesty, and integrity?
It doesn't. I think that the potential, now the legality of the industry, but at the time potential legality is a factor, admittedly, that weighs in their favor. But I think the board considered that. It discussed the fact that these games could be legal, but its conclusion was that despite the legality of skill games, they still contribute to a substantial public problem, and that outweighs the potential legality. It's the board. It's not for the Commonwealth Court to reweigh that evidence in the way that it. I think
it's not a reweigh. I don't see that's what the Commonwealth Court did. I think they clearly looked at this as sort of an insufficient evidence kind of standard in holding that. I mean, it's just association with the skill games industry in itself is totally insufficient to support the denial of the application. I mean, why is that not correct? I mean, it could be they're luring kids into their places of business. That's a different. We don't have any of that. This is just a matter of they're associated with this skill games industry, period. And consequently, that reflects negatively on their character.
So again, I would push back a little bit on the mere association. I don't believe they're merely associated with the industry. I think they're actually in. I'll describe it as them actually being in the industry.
Okay, so merely being involved in the industry.
Merely being there's no other specific evidence
There's no
about their
other
character
evidence.
honesty. So merely being the only evidence of bad character, integrity, and honesty is the fact that they sell skill games. That's the only evidence of bad character.
And that's what we call a legislative classification.
Yeah. I guess the question is, how would you feel if you applied for, you applied for a license from the Gaming Control Board and you identified yourself as being a lawyer, and the board says, well, lawyers, there's the most dishonest crew you've ever possibly seen. And they don't personally inquire about your history as a lawyer, whether you've represented good clients, whether you've done pro bono work, anything like that. They just say, you know what, he's a lawyer, and a lot of people think lawyers just
Might be a closer case.
Might be a closer case. I mean, that's what you have here, is the board, and I'm not saying you didn't, there was clearly testimony in the legislature that before a legislative committee that where people expressed their opinion, because it is opinion, their opinion view that this industry, unregulated, poses a risk. I get that. But again, put yourself in the situation of these people, and you basically get told, because you're a lawyer and people think lawyers are dishonest, we're not giving you a license.
I think under that scenario, I think there'd have to be some evidence that suggests that.
Oh, I could find plenty of people to testify about that.
Right. No, but I think there would have to be evidence in the record that would support concluding that.
That lawyers are dishonest?
No, but.
If you had a provision of the statute where, I'm not even sure this would pass muster, but suppose that this enumeration in 3301B had specifically given your board the power and duty to make these sort of categorical judgments about sectors of gaming or types of games and what have you, that would be one thing, but they didn't give you that categorical power. They did give you this character, honesty, and integrity thing, which is, quite broad and does give you a lot of discretion, not without its own, well, putting that aside. But it seems like you're trying to get that categorical classification power via the character, honesty, and integrity language.
Now, I would just point out again that I think the character assessment has to be broad. Under the board has to look at information pertaining to family habits and business activities, and that's what the board did here. It examined the applicant's actual business activities and determined that their activities were reflective of a poor character and integrity.
It is a broad power in your board, so the board could come forward with evidence that this person or group of persons are involved with organized crime, and that's clearly what the legislature was empowering you to do, but that's not at all what we have in this case.
I would push back. I think it's broader than simply looking at whether or not they have those types of associations with organized crime and the like.
That's an example, right? It's an example.
Right. I think it's much broader than that type of analysis. I think it's, like I said, we have to look at family habits, association, reputation.
But you didn't. See, that's the problem. If there were anything else in this record that suggested that there were individual characteristics of any of these applicants that reflected negatively on their character, integrity, and fitness, we wouldn't be here. But there's none of that. This is just solely being involved in this skill games industry.
So the board
legal activity.
I understand. So the board did make findings of fact regarding specific character traits of Mr. Teitelbaum, for example. He was the president of the Video Gaming Association. His work history is the board made findings of fact regarding his work history and so forth. So I don't think it's fair to say that
what about his work history showed that he lacked integrity, character, and honesty?
Nothing. I agree, Justice Brobson. I don't think there was anything about his background other than his participation in the industry that.
Excuse me, if the applicants ran strip clubs, would you exclude them for that reason?
I'm not sure what the board's position on strip clubs would be, but I mean, I think if there was evidence suggesting that their business activities, cause problems for the public, I think that's a factor that the board would weigh. But like I said earlier, I think in any character determination, it's a weighing of the positive and the negative character evidence. And I think the board does have that discretion. It's written into the Video Gaming Act. And I think it's a principle of appellate review that appellate courts aren't supposed to substitute judgment and reweigh evidence, which our position is that's essentially what the Commonwealth Court did here.
Well, I think the Commonwealth Court decided that under the statute, they interpreted the statute, and under the statute, the evidence that was presented was insufficient to go to these issues of good character, honesty, and integrity. I mean, maybe we have a disagreement on how you could read the Commonwealth Court opinion, but I think in their determination, they concluded that essentially involvement in a legal activity without more is insufficient to meet that statutory burden.
So I would agree with you, Justice Donahue, if the Commonwealth Court had actually used principles of statutory construction and defined what good character, honesty, and integrity means, but it didn't do that. It simply, in our opinion, it discussed the evidence that was presented to the board and used its own judgment and reweighed that evidence in the way that it saw fit.
Well,
so
they said the statute was unambiguous, and it seemed to me that they concluded that given the statutory terms, good character, honesty, integrity, in their view, that would preclude a finding that involvement in a legal activity in and of itself is insufficient to meet that standard.
I'm not sure that's what the Commonwealth Court was saying in that citation.
It almost doesn't even matter what the Commonwealth Court was saying, because we're going to review this. We're going to review what the agency did here, and not necessarily what the Commonwealth Court did.
I understand.
But you can skin the ruling any number of ways. Either the court ruled as a matter of law that evidence of participation in industry that is lawful alone, as a matter of law, cannot be evidence of good character, or they review it as a substantial evidence test and say that if the only evidence is they participated in an industry and there's opinions that the industry poses a threat, that is not substantial evidence to support a finding of fact of lack of good character, honesty, and integrity. Either way, it was within their province to do that, unless there was somehow, like you say, some sort of a weighing dynamic going on and they were reweighing. But I'm still trying to figure out the question is whether you have anything on your side of the scale. That's the question. Do you have anything on your side of the scale showing an individualized assessment of bad character, dishonesty, and lack of integrity?
So I think the board made findings of fact regarding the positive character evidence that was before it. Like I said, Mr. Teitelbaum's background. I understand, but on our side, it's admittedly it's simply their distribution of skill games, which, according to the testimony from Major Miller and Mr. Sficco, caused the problems with. Cause the public problems.
It's not their distribution of skill games that cause problems. It's the distribution of skill games that cause that generally is the opinion, right? There's no evidence about their distribution of skill games that causes problems.
I think that's fair, but relative to, I think a lot of the problems discussed by Major Miller and Mr. Sficco do apply to their distribution of skill games, even without testimony specifically about what the operators that they distribute to actually are doing. I think they're obviously unregulated, and that was the crux of the board's concern, the lack of regulation and control. And because they're unregulated and there are no controls, we don't know what the operators are doing. That was the crux of the board's adjudication, that these games are unregulated, and therefore because they lack those protections, they present problems to the public. So I think that's the other side of the scale. The board considered that to be the overarching concern that outweighed any positive character evidence that was presented.
Okay, let's hear from your opposing counsel.
Thank you.
Good afternoon, Chief Justice Todd, Justices of the Supreme Court. May it please the Court. My name is Helen Gemmel. I am here today with my colleagues Drew Crompton and Austin Huey. Together we represent the Applees, Better Bets Ventures LLC, Michael Brazetti, Frank Brazetti Jr., Lendl Gaming LLC, and Richard Teitelbaum. These were the applicants for the video gaming terminal licenses. Contrary to the statement of the issue that was presented for this court for review, the Commonwealth Court did nothing in this case to take away any deference that was owed to the Gaming Control Board. And I think what Justice Brobson just said, that you can look at this two ways. Either the Commonwealth Court made a decision as a matter of law as to whether or not the statutory words good character, integrity, and honesty are something that you can categorically say if you're in an industry you can't possibly be within those words. Or the Commonwealth Court made a determination that there was not substantial evidence to support the finding that the Gaming Board made. Either way, my clients should have been granted their licenses. Let me first turn to the issue with respect to a question of law. This court has been very clear that no deference is given on legal questions. The interpretation of a statute is the province of judges. That's our Crown Castle case that Justice Mundy wrote the opinion for only about 4 years ago. And I think I'm actually going to quote some language from Justice Weck's concurring opinion.
Is it in Latin?
It is not in Latin this time. Fortunately,
I hope I at least quoted Justice Holmes.
This is in English, and what the Justice Weck said is that courts should respond to agencies' requests for deference by saying, don't command me, convince me. And as I sat here and listened to the argument from my counsel, co-colleagues at the Gaming Board, I was not convinced that the way that this statute should be interpreted as a matter of law is to remove an entire category of industry from people who have good character, honesty, and integrity. The examples that this court has come up with are very good. Strip clubs, bar owners. I was thinking of wholesale cigarette licensing. That's very bad in terms of what it can do if minors get a hold of cigarettes. But those are entire categories that have nothing to do with these particular individuals. There is nothing in the record that says that Mr. Teitelbaum or Mr. Michael Brazetti or Mr. Frank Brazetti do any of these things. In fact, there's even a disconnect between them being in the skill game industry where they supply the products to bars, restaurants, places where they are, and then how they are then operated there. So not only is the Gaming Board saying you can't even supply them, somehow, even though there are no regulations, you have to monitor them every night to make sure that a 17-year-old boy does not get anywhere near this machine.
Well, I think under their view, that wouldn't even matter. Like, that wouldn't even matter.
It would not even matter. You're correct, Justice Brobson. It would not matter whatsoever because just being in the industry is enough to say that you've got bad character, you are dishonest, and you lack integrity. And even when you look at the testimony that they had, let me turn to the substantial evidence part of this as well, because that's really the standard that the Commonwealth Court, in fact, any court must use when reviewing a decision of an agency. Section 704 of the Administrative Agency Act says what the Commonwealth Court is supposed to do when reviewing. You look for an error of law, and then you look to see whether findings of fact are supported by substantial evidence. And I think a good example of how this comes up even in the gaming context is the decision that's cited in the Commonwealth Court's opinion, the Sonic Services case, which the opinion was authored by now Justice Brobson.
It's dangerous when you cite opinions.
When you look at that case, you say, all right, what was the evidence that was there? The evidence that the Gaming Board had was that the applicants were associated with 3 individuals who had criminal convictions and who were reputed to be part of organized crime families. And in now Justice Brobson's decision, he looked at 2 of those people and said, well, the interactions that they had with the first person, the second person, those were too limited to be substantial evidence of an association with organized crime. That's the process you go through. Then the opinion looks at the connections with the other individual and found out that those were sufficient connections to find that the applicant had those connections to a person who had criminal convictions and was involved in organized crime. When you look at this language, good character, honesty, integrity, in this Pocono Manor decision that this court decided many years ago, you looked at what that language means. You said this was intended by the legislature to ensure that we avoid corruption, a perception of corruption in the gaming industry.
Counsel, let me play devil's advocate. Share with us, pursuant to 3301, B2 and 11, why is it when you look at the laws that the General Assembly has permitted the board to have at its discretion the ability to determine based upon clear and convincing evidence that a person is of good character, honesty, integrity, if the associations of that individual do not pose a threat to the public interest? How is it an abuse of discretion if based upon their authority and the testimony of the Pennsylvania State Police Bureau and the executive director of the Pennsylvania Lottery that the board deemed character of issue because these individuals, your clients, were associating with what they had heard testimony of is a possible threat to public interest? They have the discretion. We give them great discretion. Share with us how that's an abuse.
Sure, we absolutely do give them discretion, but it is not unfettered discretion. So if it was unfettered discretion that could not be reviewed by this court, then we would not have Section 3304 that says you have a standard of review on appeal to the Commonwealth Court, and here's our standard of review on appeal. And then what does that standard say? You have to have substantial evidence. That a reasonable fact finder, someone with a reasonable mind, would look at that evidence and reach the conclusion that was reached. So what do we have here, Justice Doherty? We have testimony given by 2 individuals to an oversight gaming commission who say this industry is bad. And it's bad for several reasons. Minors can play these machines. It takes away money from the lottery because if you play this game, you're not buying a lottery ticket. We don't collect taxes. They pay things out in cash. Those are the things they are talking about here. But is that substantial evidence of the character, good character, honesty, and integrity of these individuals? The people who testified before the Oversight Committee, before the House of Representatives, to my knowledge, they never met my clients. They know nothing about them.
They're arguing before the legislature for a categorical. That's what legislatures do, whereas the board does individualized determinations pursuant to the authority the legislature has given them. Isn't that the delineation?
That's exactly what they're doing. They're trying to convince the legislature from a policy standpoint that this is what the legislature should adopt as the law of the Commonwealth. And to this date, the legislature has not done that. So when you're looking at that evidence, going back to Justice Doherty's question, where you're looking at that evidence, can the Commonwealth Court say this evidence itself is not substantial evidence that supports the conclusion, which was reached, that because Major Miller and Mr. Svitko think there are problems with this industry, now we have to conclude that people who are in this industry are categorically corrupt, they lack good character, they are dishonest, they lack integrity? There is not substantial evidence of that. So we cannot just abdicate to the gaming board the role that this court has to look to see whether or not are they applying the law, did they make an error of law, or was there substantial evidence to support the conclusion that they reached? And they just simply don't have that here. The skill game industry may not be the best industry in the world. Maybe the legislature will tell us that someday. Maybe this court will make a determination with respect to skill games and that they are bad things. But that's not the record that we have before us today. The record we have before us today, the record that the Commonwealth Court had before it that day, was that the only thing that is negative about my clients, the only reason why they were denied a license, is because they are in an industry that the gaming board thinks is bad. That is not evidence of my client's good character, honesty, or integrity. Under these circumstances, the decision of the Commonwealth Court should be upheld. They did everything that they were required to do as a matter of law and as a reviewing court to determine if there was substantial evidence. And I'll make one more point that I think keeps coming up in the gaming board's decision and their briefs, is that there was some sort of weighing of evidence that happened here, and that somehow the Commonwealth Court stepped in and they tipped the scales. This is not based upon a credibility finding where the Commonwealth Court said, well, gaming board, you found them credible, but we don't. That's not what we have here. There's not like there was a lot of evidence of good character and some evidence of bad character because something was specific to one of these individuals, that the Commonwealth Court kind of went back and forth and said, yeah, I think I would look at this differently. There was no reweighing of evidence. It was the application of the known standards that this court has set that as a matter of law have to be applied. Was there an error of law? Well, to the extent that the gaming board says that good character, honesty, integrity mean you can't be in an industry as a matter of law, then I'd say there is an error of law. Was there substantial evidence to support their finding that these people did not have good character, honesty, or integrity based upon the testimony of two people before an oversight house committee? That is not substantial evidence. Under these circumstances, the decision of the Commonwealth Court should be affirmed.
Thank you very much. Thank you both, counsel. Mr. Minner, would you call the next case?
Wunderly, Executive of the estate of Kenneth Wunderly versus St. Luke's Hospital of Bethlehem Health. Representing Ms. Wunderly, Mr. Matt Gallagher. Representing the Kelly, Ms. Marie McBride.
In this appeal, an individual suffering from dementia was involuntarily committed to a hospital under Section 302 of the Mental Health Procedures Act. While in the hospital, he developed serious bed sores that ultimately became infected and led to his death. His wife, as executrix of his estate, filed a claim for professional negligence against the hospital. The hospital filed a motion for judgment on the pleadings, which the trial court granted on the grounds that under Section 114A of the Mental Health Procedures Act, the hospital was immune from complaints of ordinary negligence while providing inpatient mental health treatment. Rather, the trial court reasoned that a plaintiff must show that the acts complained of amounted to a willful misconduct or gross negligence, and that executrix did not do so. The Superior Court affirmed, and we granted review to address the propriety of that decision. Please proceed.
Thank you, Chief Justice Todd. May it please the court, my name is Matthew Gallagher. I represent the estate of Kenneth Wunderly. The immunity provisions of the Mental Health Procedures Act do not apply to Mr. Wunderly's nursing malpractice claims because failure to provide treatment for physical ailments like unrelieved pressure are not immunized under the Act. Section 104 of the Act and this court's precedent tell us that treatment immunized under the Act includes medical care coincident to mental health care and care and other services that supplement treatment in order to promote the recovery of the patient from mental illness. But most importantly in this case, plaintiff alleged not merely negligent provision of wound prevention or wound care, she alleges that the defendants altogether failed to provide wound prevention interventions like turning and repositioning. Both the trial court and the Superior Court, in our view, failed to appreciate the import of these allegations, and we ask that their judgments be reversed.
Counsel, whether you win or lose, whatever we do is going to set a standard which would hopefully differentiate or delineate between what's provided under the Act and what's not. What do you propose to us by way of a dividing line between medical care afforded to patients under the MHPA and medical care not provided under that, covered under that?
Sure.
What's a clear dividing line that we could use?
So, Justice Wecht, I would suggest that this court reaffirm its prior holdings in cases like Allen that have made clear it is not just the provision of treatment for a physical issue for someone who's admitted for mental health treatment. I think as the court said in Dean, the Act is not implicated anytime there's any issue related to mental health at all. What the statute says and what this court has said is that for care for a physical ailment to be immunized, it has to be care that's provided to promote the recovery of a patient from mental health. So the three cases that I think are most on point that I discussed in my brief, I think make that distinction very clear. For example, the Allen case, which is probably the most important case both sides have briefed, that was a case in which there was physical injury, and the injury came from a restraint vest that the patient was receiving explicitly, at least in part, because of her mental health conditions. I think it would be fair to say that no one would need the kind of restraint that patient received if it were not for a mental health condition. The Superior Court in the Downey case, that was the case where, and all these cases, the court found immunity, so they go against me, but I think they're important. The Downey case was the case where the mental health patient drowned, and the allegation was, well, she was not supervised, she should have been supervised, she wasn't. Again, the reason that kind of patient would have allegedly needed that kind of supervision was because of her mental health conditions. I think the Superior Court talked about her being childlike, confused, incontinent. I forget all the descriptions, but it was clear that the alleged need for that supervision came from her mental health conditions. And then the Farrago case that this court decided, I believe after Allen, that was a case where a mental health patient was raped by a fellow patient. The allegation was the facility did not supervise her closely enough. The treatment plan put in place for her was essentially, we're not going to provide her one-on-one, 24-hour, arm's-length supervision. We think, in the exercise of our judgment, that having her on occasional observation, I think every hour, or it may have been in a group setting, would be sufficient. So again, those are all decisions made because of issues directly related to the mental health treatment that patient was receiving, that it's our position directly implicates the Act. In all of those cases, the rationale for the Mental Health Procedures Act, it makes sense. This court has said many times this is an inexact field. One of the purposes behind the statute would be not to second guess a mental health provider for every judgment call in those situations. But in those cases, the plan was followed. It may not have been the right call, but it was a coin flip call. The plan was followed.
Counsel, is dementia a mental health condition?
It is.
Well, if someone with dementia, someone suffering with dementia, cannot discern whether or not he should be turned or should be not putting pressure on bed sores, isn't that in the same category as the cases you've just described?
I wouldn't say so, Your Honor. I think a patient like that who may not be able to tell either ever or maybe on some occasions that they can't be turned, that's the reason that the defendants in this case put a plan in place. And I think that's what distinguishes many of these other cases where the plans for these mental health interventions, trying to comply with the statute's mandate to impose the least restrictions possible, their plans were followed. In this case, conversely, the defendants had a plan, and I think it's in the reproduced record 135B. When Mr. Wunderly was admitted to their facility, they put a plan in place that said he is at risk for skin breakdown, he needs to be turned and repositioned every 2 hours, presumably because he was precisely that kind of patient. As we all shift and move in our chairs, he either physically could not do it, did not know that he needed to do it, or some kind of combination of the two. So I think that's the dividing line between these cases.
I'm not sure how that answer to the Chief Justice helps you, because that plan was, you're basically saying, is attributed to his mental health condition.
And I think I should clarify, it's not clear whether the need for his turning repositioning was because of his mental health condition,
well, now you're
or
not
just
being clear, you're just changing your position. I mean, you seem to respond to the Chief that, you know, this was, when he was admitted on the hold, he was admitted for his condition of dementia. I presume maybe it was because he was aggressive or a danger to himself or a danger to others and couldn't be controlled or what have you. That upon intake, it was noted that part of the plan includes having to reposition him and things like that. But you're now, you on one hand were saying that it was related to his dementia because he couldn't, as the Chief said, discern whether to turn or not. But now you're saying, oh no, it was completely different. See, this isn't a case where somebody under a 302 hold develops an appendicitis and needs surgery.
Right.
The question is whether the treatment here, the bed sore treatment, was coincidental to the 302 hold. Did it have some connection to the mental health condition that prompted the treatment? That seems to me to be the dividing line here.
And Your Honor, I probably took what's in the record too far in the sense that their plan of care for him that called for turning and repositioning, it did not say, well, my response was, in some situations, I think it could be, but their plan of care did not say, we are putting this intervention in place because simply he does not know that he needs to turn himself, as opposed to he is just physically unable to complete that task himself, which is what necessitates the staff providing that care for him.
What was the cause for the bed sores?
I'm sorry?
What was the cause for the bed sores upon admission? What's the mobility issue with the deceased? What was the mobility issue?
Sure. So on admission, he was noted to only have a stage 1 wound to his backside, which is essentially superficial redness.
But he had a mobility issue.
Correct.
What was the nature of the mobility issue?
So the record at this point, I would say, is not fully developed on that issue. There are references to, with other activities of daily living, with transfers around the unit, that he did require assistance of multiple staff members to complete those tasks.
Well, presumably, if he had dementia, he may not have been able to articulate, I'm having pain, I need to be turned.
Correct. That may be the case. And, Your Honor, our response would be that, and we see this in many malpractice cases, even if there is a patient who's not able to comprehend that they need to do that turning, the pressure...
Or to ask for help, right?
Correct. Correct. The pressure injury is inflicted not from their confusion, it's inflicted because of the pressure. So regardless of whether the person is aware of the pressure or not, the staff, according to their own plan, would need to provide that care for him so that these kind of severe wounds don't develop.
So if I'm listening to what you're saying, you're saying that there's a plan of care for somebody. I mean, Justice Brobson just touched on the language from Allen, which was coincidental, care that's coincidental to the mental health treatment. You're suggesting to this court, and I guess in response to Justice Wecht, is that we should be looking at errors of commission as opposed to errors of omission? In other words, if it's part of the plan of care and it's an error of commission, that's covered under the Mental Health Act. If it's an omission that they've neglected to put this particular care together as part of the plan of care, then that's something that falls outside of the Mental Health Act?
Justice McCaffrey, not necessarily. I think there could be negligence.
I was trying to give you an out there. You sure?
I'm sorry?
I was trying to give you an out there. Are you sure?
But I think there could be situations where there could be negligence related to treatment of a physical ailment that is.
Well, then let me circle back to Justice Weck's initial question to you. What's the bright line here? In other words, we're going to be asked to define or expand upon Justice Castillo's language in the Allen versus Montgomery County case, coincidental care. What does that mean to you?
So, Your Honor, I would say that this court summarized the issue well in the Dean case. And I know that wasn't the same circumstance with an inpatient admission, but the court said that it had, in prior cases, extended immunity under the Act to healthcare providers that provide medical care for physical ailments associated with treatment for primary mental illness. And also, again, citing the statute and the Allen case, treatment that, in Dean, this court said that the immunity might apply to treatment that does not specifically pertain to mental illness if the treatment facilitates the recovery from mental illness. So our perspective is that if the defendant had provided this care as they were supposed to do, as they had care planned and said they needed to do, it would do nothing to facilitate the recovery from mental illness. It would merely facilitate Mr. Wunderly's recovery from unrelieved pressure on his backside.
Counsel, if you could clarify for me, when he was admitted because of his dementia, is that correct?
Correct.
And at the time he was admitted, he had the beginnings of bed sores?
Correct. They were stage 1, which is about as it's the lowest stage, as superficial as they get.
So he was admitted because of his dementia, and he had bed sores that required treatment. Were they
Correct.
They were two different issues.
Correct. I think the record's clear that the primary reason was for the dementia. There was recent aggression, but they did note
the treatment of the bed sores didn't have anything to do with the treatment of the dementia. It had to do with the fact that he was admitted with developing bed sores.
Correct.
Which went untreated.
Correct.
Which had nothing to do with the dementia.
Correct.
Are you sure that's what you alleged?
That's what I understood
People don't
you just
typically
said.
get admitted to the hospital for a stage 1 bed sore.
No,
Your Honor.
No.
We acknowledge he was admitted for the treatment of his mental health conditions.
Right.
They noted a stage 1 wound on admission, but that's not the reason.
But that's like noting an ingrown toenail.
Right.
No, we're not suggesting that the reason he was admitted was for the physical.
Okay.
Well, upon admission, he was placed in a bed, right?
Correct, at some point.
So wouldn't that give rise to, some expectation that in connection with his treatment, he's going to also be treated for anything that is impacted by his lying down on a bed?
Presumably, yes, and I think that's probably why they created the care plan. They recognized that this was someone who would need assistance with that kind of pressure relief.
Because he was immobile due to the dementia.
Well, again, I'm not sure if the record's clear that his own immobility was because of his dementia versus just.
So we don't know whether he suffered from MS or anything like that. It's not in your complaint as to why he was immobile and developed bed sores.
No, Your Honor, I don't believe so.
Well, how do you deal with the broad language the legislature chose to put into section 104, which says treatment shall include diagnosis, evaluation, therapy, or rehabilitation needed to alleviate pain and distress and to facilitate the recovery of a person from mental illness, and shall also include care and other services that supplement treatment and aid or promote such recovery. So I guess what I'm asking in light of that definition is if the treatment plan, and I assume once a history and physical was taken, that the treatment plan included something about these ulcers, that we could later pick apart that care from the principal issue that he's there for, which is mental health.
So if I recall correctly, Your Honor, I don't think the history and physicals from the physicians on admission noted the pressure wound present on admission. The plan of care came from the nursing staff, which would be the ones taking care of the turning and repositioning care. In terms of how do we deal with that section of the statute, I think the most important part in those definitional sections is the word and. Treatment immunized under the Act is not just, and admittedly these are broad terms, but alleviating a person's pain and distress, diagnosis, evaluation, therapy needed to alleviate pain and distress. But the important part in our view is and to facilitate the recovery of a person from mental illness. Our view is that, again, if the defendants provided the offloading care, the wound prevention care that they themselves said needed to be done, it's certainly important, as we saw.
Especially if it was contributed to by the mental illness.
I'm sorry?
Especially if it was, if a substantial contributing factor to the bed sores was the mental illness.
Perhaps, Your Honor, and the reason I pushed back.
By the way, this patient was never going to recover from dementia.
Correct.
No.
So I mean, I'm not sure how this act really applies to a dementia patient on a 302 hold unless they're just in there for a medication adjustment. But anyway, to me the line that seems to be reasonable, and tell me I'm not reasonable, was the medical care that was provided coincident to the mental health care that they were admitted for? Is there a connection of some sort? Again, I differentiate from they're in on a 302 hold and they develop a appendicitis that goes undiagnosed or something like that. Why is that line, which seems to be consistent with Allen, that there's some connection between the mental health condition and the other condition that we're talking about?
I think that is the standard that should apply, Your Honor, and I think certainly Mr. Wunderly, the records would show he did receive some medical care coincident to his mental health care, but I think why this case is different is not just, well, maybe they used one wound treatment, they should have used another.
You're talking specifics. I mean, I'm talking about the actual subject of the medical care. I'm not talking about how they delivered the medical care. How they delivered goes to whether they engage in negligence, gross negligence, or reckless misconduct. I'm talking about the particular medical care to determine it falls within the subject of the act. Allen draws a connection, right? I'm asking you, shouldn't that simply just be the focus in here? If the wound care, if the wounds, the medical condition that was treated or negligently treated or not treated, however you want to phrase omission, commission, if it was related, somehow connected to the purpose for which he was admitted, meaning his dementia, the mental health condition, why shouldn't that be the line? If it was connected, if it was coincident to the mental health condition, you have to allege gross negligence and reckless disregard. And if it's not, if it's unrelated to the mental health condition for which they were admitted, then you can go to regular negligence.
I think that is the line, Your Honor, except that in this case we're alleging that there was no care provided for these physical ailments at all.
But that doesn't go to what standard is. You don't seem to want to answer the question. Is the standard negligence, gross negligence depends on whether the wounds were connected to the dementia. And that is the answer to determine whether there's immunity or not. That's the gateway question.
I understand.
Do you agree with that?
I think so, because in the standard that this court set in Allen, we're not asking to abrogate that standard. Our point is that the immunity under the Act and the reasons for that immunity, given the inexact field of mental health, have no application. And again, I realize I'm talking specifics, but in a case where there is, again, we're at judgment on the pleadings, accepting these allegations as true, we're alleging that there is no treatment provided to prevent wounds at all.
Yeah, but counsel, that's a different question. How is he being treated for the dementia? Was he immobilized?
Not fully, Your Honor. I know that he was medicated.
Because if he was immobilized in order to treat the aggressiveness that was caused by the dementia, and the immobilization resulted in the bed sores. You'd be smack dab in the middle of Allen, wouldn't you?
Probably. I will say in this case, he was certainly not strapped to the bed and completely immobilized. There are references to him being up out of bed, being in a chair, being out and around the unit. So I understand the point. I don't think this is one of those cases.
Okay, Mr. Gallagher, if we're going to have to take a close look at this record, obviously, in deciding the case, but let's hear from Ms. McBride.
Thank you, Your Honor.
Good afternoon, Chief Justice, Justices. Maureen McBride for the St. Luke's defendants. With me, Your Honors, I have Laurie Shannon, who was trial counsel from Kilcoyne and Nesbitt, and then my associate, who's always very helpful with the briefs, Andrew Stafford. Your Honors, a few points I want to make in response to my opposing counsel's remarks. I believe that these issues, or the issue of this case, has been decided by this court in Allen. It's clear that the care was coincident to mental health treatment under the statute. It relates to services provided. Let me just preface that by saying there's no argument that the hospital is a person under the Act. The issue with respect to treatment, adequate inpatient treatment, which he was, shall include such accommodations. It includes everything: diet, heat, light, sanitary facilities, clothing, recreation, education, and medical care necessary to maintain decent, safe, and healthful living conditions. He was an inpatient.
Wasn't this really a failure to treat, though, not a treatment? I mean,
So,
that's what I meant by commission as opposed to omission.
I thought that was going to be the argument today, and I'm not sure that that's exactly what the position is of the plaintiff. But that argument clearly doesn't apply, because the case law, first of all, there was a plan in place. It's in the medical records. There was a plan for him. He was on, and he was on, I don't want to say some kind of drugs. He was given group therapy, other types of therapy. So he's definitely in there, a 302 hold and a 303 hearing. So he's there for mental health treatment. And then, of course, they provide the accommodations for him. This court in Allen did not draw the distinction, or in any of the cases, between omission and commission. But a fundamental point that has to be raised is that the allegations in the complaint, there are no facts in the complaint whereby the plaintiff alleges that he was not turned over, or that he was ignored, or that any of that. All that is alleged in the complaint in terms of the facts are that he entered the facility with a stage 1 bed sore and left the facility with a worsened bed sore. That's it, nothing in between. In the complaint, the plaintiffs then make an allegation in terms of the counts that, well, it must have been because he wasn't turned over, or it must have been because of this. But they also allege numerous allegations about the failure to provide proper care or appropriate care. So it's both affirmative and the allegations of commission. But there are no facts, and the trial judge pointed this out. There are no facts in the complaint that in any way suggest that he wasn't turned over. That's not even mentioned in the facts. It's just that he came in with one and left with one that was worse.
Does it depend, Ms. McBride, on the, does application of the statute depend on the relative quantum of treatment that is mental health versus physical symptoms? If so, how would we make that determination? Or is it, or is it, does it turn on the primary purpose of the admission? And suppose, because if it's either of those, suppose he was primarily admitted for the ulcers, and then he got psychiatric consult. So it's sort of, I guess, the opposite of what happened here. Would the same result apply in your view?
In my view, Your Honor, I think if he's admitted as a 302, he's clearly there for mental health treatment. He's in the hospital physically only for that purpose. And he was combative, he was aggressive, there were a lot of things that they needed to do and treat. And by the way, you know, this is why we have the immunity, because this population of patients are very difficult to treat. And so there are lots of things, and of course we want to encourage, you know, physicians to treat these patients, and we want to give them the least restrictive
Are
means.
you conceding, I'm sorry to interrupt,
I'm
just
sorry.
a thought, are you conceding then that the, that the standard should be limited to cases where the admission was under the Act?
No, I don't think that that's, no, I don't think that's the case. I do think that when you're admitted under the Act, that's a pretty clear indication that you're here for mental health treatment.
If you're not admitted under the Act, you're admitted because you have these ulcers. So you're primarily there under dermatologist care, but it's severe enough that you're admitted. Then the physicians surrounding detect there could be a severe mental health problem here. They bring in a psychiatric consult. So my question is, does that bring all this under the immunity provisions then?
I think arguably, yes. I mean, again, it's anyone who participates in a decision that a person be examined or treated under the Act shall not be civilly or criminally liable for such decision or any of its consequences.
So then my last question, and then I'll stop, is does that mean then that a healthcare facility could just, with respect to a patient admitted for some non-mental health issue, just attach at any point in the treatment, a psychiatric consult, a social worker consult, and thereby import immunity for any malpractice claims with respect to that patient? Because if that's the case, then you could see a perverse incentive for prophylactically grabbing immunity from malpractice claims, couldn't you?
I take your point, but I think the Dean case, this court addressed the issue with respect to someone who went in for drug rehabilitation. And I think that case stands for the proposition that if you're in for a reason that may somewhat look like mental health, but it's not, and maybe you do get some treatment, I believe that the court said there was no immunity in that case. And if you are treating a patient who happens to have mental health issues, but you're treating them for something else, then the immunity arguably would not apply. But this case falls squarely into Allen.
I just want to give another hypothetical and make sure I understand.
Okay.
Again, I'm trying to draw this line.
Right.
You have a person suffering from dementia that is living in a memory care facility. And while in the memory care facility, the person falls and breaks their hip. The memory care facility has been providing the medications that the psychiatrist has prescribed to keep them on their meds, things like that. They now go out of the memory care facility to the hospital for what turns out to be hip replacement surgery. As a result, the hospital still has to keep them up with their medications and things like that. Botched hip replacement. Does the Mental Health Care Procedures Act apply, or is it regular negligence?
I think if the facility is providing mental health treatment, and again, that is the population of people, you know, that this statute was created to protect against those kinds of claims for that population, because people with memory care, people with psychiatric issues are a difficult population to treat. And perhaps...
Well, not when they're unconscious under sedation. I mean, my hypothetical was not they were not going to the hospital for mental health treatment. The only thing the hospital did was keep them on their medical regimen and did a hip replacement surgery. And while the dementia patient was sedated, they botched the surgery.
Okay, I think that the immunity applies if the person is being treated under the Act. If there is mental health...
Well, I'm asking you under the hypothetical I gave you, is the person being treated
I believe the person is being treated under the Act if they're getting mental health services, and that care is coincident to that. That's what this court said in Allen.
Except the mental health care in Justice Brobson's hypothetical, which I think is a very pertinent and timely one, you know, looking at our society, right, is that the mental health care in that circumstance would be would be the tail. The dog would be the hip replacement, right? She fell and she injured her hip. She goes in for a treatment of that, and the orthopod decides there's a need for a hip replacement. You're not telling us, are you, that whole category of such claims would then be immune from med mal cases?
Well, I mean, first of all, we have the gross negligence standard, which could overcome the immunity. So I just want to make clear that there would be a remedy. Now, I think you have to look at the purpose for which the person is there. I mean, if the person is there because they were in an assisted living facility and became disoriented and broke a hip and was getting hip replacement, you know, that could be a situation where they're being treated for mental health and they're getting care. If they were perfectly fine and fell in the facility even though they didn't have a memory and came to the hospital and had the hip replacement, that could be a different issue.
You're saying two things, Ms. McBride. Now what you're saying is that anyone with a diagnosed mental health condition in an assisted living facility or memory care facility that suffers any kind of medical condition that requires treatment at a hospital, the act is triggered.
No, what I meant to say was that if they were perfectly fine in the facility and then came because they had a broken hip, the fact that they have a mental health condition or memory loss wouldn't control. But if they came to...
That's the hypothetical I gave.
Okay, but if they came...
A patient at a memory care facility has dementia, is on medications being treated by a psychiatrist at the memory care facility, falls, diagnosed with a hip fracture, gets taken to the emergency room, gets admitted by an orthopod for surgery, and the only mental health treatment that the hospital is doing at that point in time is just making sure they stay on their meds.
Right. I think so that's Justice Weck's point, that when you're talking about care coincident, I think the care has to be coincident to the mental health treatment, not the other way around. Yes. This case, clearly, because he's a 302 and a 303, it's coincident.
Could you explain that to me? And maybe I'm just a little bit confused on the facts, but this gentleman was admitted for dementia. He was aggressive.
Yes.
As I understand it. But he also had the first stages of an ulcer,
right.
Correct?
Yes.
Okay, so when he's admitted, he has that also. Yes. What is the standard of care for treating this other injury, which may or may not have anything to do with the dementia? He has a first stage ulcer. Under your theory of liability, don't they have to treat that other condition? And they did, Your Honor. If you look in the medical records. But they pleaded, I'm just looking at the pleadings, so to speak, but one of the allegations was the failure to monitor to prevent the formulation of pressure ulcers. Let's assume that's true. Okay, is that coincident to the mental health treatment, or is that just totally because of the fact that he had an ulcer when he came in that needed to be monitored? Okay, let me just say two things to that. One is that was not a fact that was pled. That's an allegation, and what the plaintiffs have said is that must be the way it happened, because he came in with a 1 and he left with a 4, and therefore they must not have turned him over. There are no facts on that. The actual pleadings, because this is motion for judgment on the pleadings, so the medical records are attached to the answer in new matter. They have an entire plan here to apply nourishing cream to the skin, offloading, do all these things. I mean, this is all in the plan that was signed off on by the spouse. So again, we have allegations, we don't have facts, so there are no favorable inferences, even to the point of they didn't turn him over. Is that coincident to the treatment of the dementia? Yeah, I believe so. If he came in under the circumstances that he was involuntarily committed for mental health and aggression and violent behavior toward his wife, and he had a psych consult, he was given drugs and therapy for his mental health condition. Clearly, that's the purpose. So anything else that happens during that admission is coincident to the treatment of the mental health condition? Yes, I believe so. And I think, again, if there was gross negligence, they could bring that out.
I'm sorry to interrupt, but I just want to ask Justice Brobson's example. What if he had an appendicitis in the middle of this stay and nobody treated it. Is that still coincidental to his mental health?
I believe again, and I think if you're there an involuntary commitment, and again, this is the policy and purpose of this act, is because this is a difficult population, and especially with respect to bed sores. One of the amicus briefs that was filed on behalf of the hospital points out that this population, people with mental health issues, are more susceptible and tend to have more bed sores than the rest of the population. So again, we're dealing with a very difficult group of people, and we're trying to give as much latitude as we can to doctors, but not if they're grossly negligent. That's a way to overcome that immunity. But to start with the plain language of the statute, again, the hospital is a person, the treatment falls right within the act, care is coincident, that's this court's decision in Allen.
Counsel, if the plaintiff is arguing failure to act, and you just told us that in the evidence there's a treatment plan, and yet the evidence is that the patient was worse from 1 to 4, as you indicated, isn't that indicative of willful misconduct? Because it's obvious your treatment plan is not working, the patient is getting worse with the medical condition, separate and apart from the dementia.
Bed sores can get worse even with treatment. So you can't infer that what they're saying is correct, that the treatment did not happen. That is not true. Bed sores are very difficult to treat, and he came in already with a bed sore.
Stage 1 or
Stage 1, right. But let me just address the issue of commission versus omission, because this court addressed that in the Farragut case, where they made the same argument that it should only apply to affirmative conduct, not to any omission. And this court said, no, we're not going to draw that line, because it's easy to plead around, instead of saying you didn't do this appropriately, everything would be pled in, you failed to do this, you failed to do that. But that's certainly enough to maintain a cause of action against a doctor or hospital. People talk about failures all the time as if that's treatment, right? I mean, that would qualify as a cause of action. So the same should hold true for hospitals and physicians, that is considered treatment. I just want to point out one other thing, that the Superior Court recently, in October of this year, issued a decision in Toth versus Chambersburg Hospital addressing almost the identical issue. An opinion by Justice Stevens, and he reached the same conclusion. I don't have the A2 site, but it's 208 MDA 2024, October 15th, 2024. It is a published decision where he goes through the same analysis and talks about treatment and aid in recovery coincident to mental health care, and just talked about the exact issue in this case. In fact, they asked the court to hold that case for this court's decision in Wunderly, and the court didn't do so. But I think it's important, again, that we put the context here. We're not talking about a case where somebody came in, with a broken hip and happened to have dementia. This is the other way around. This is where somebody's primary purpose was to get stabilized because of severe mental health issues. That treatment was provided, and the person left with a condition. But that clearly, falls directly within this court's, those 3 decisions that I mentioned, and I think the Superior Court was correct, the trial court was correct to apply that, and in order to really to decide this in plaintiff's favor, this court would have to overturn the decision in Allen, and I don't believe that the facts in this case require that.
All right, thank you very much.
Thank you.
Well argued by both. Mr. Minner, would you call the next case?
Steets versus Celebration Fireworks Inc. Representing Steets, Mr. Daniel Siegel. Representing Celebration Fireworks, Ms. Sherry Dodd.
Yeah.
The appellant in this appeal was involved in a tragic explosion while working for the Celebration Fireworks, causing traumatic injuries to her brain and other parts of her body. She was awarded total disability benefits and specific loss benefits under the Workers' Compensation Act. She died 3 years later from complications from her injuries. We granted review to address whether specific lost benefits, which were awarded to the claimant before her death, may be recovered by the claimant's estate when the complainant died as a result of her work-related injury. You may proceed.
Good afternoon. May it please the court. I'm Daniel Sigel, and this is Gerald Strubinger, who handled the case throughout the litigation process. The Workers' Compensation Act has always permitted the award of benefits, including specific loss benefits, to those who died as a result of the work injury. It was not until, and it was 1972, when the legislature granted benefits to those who did not die from the work-related injury and died from a separate injury or a separate cause, that caused the amendment to cause grossly inequitable results. The decision to give benefits to those who died from a cause other than the work injury cured one problem, but it did not mean that the legislature intended. There's no legislative history that indicates that. There's nothing to the contrary. In fact, the Act suggests exactly the opposite, that to give benefits to those who both died from the injury and those who didn't. Doing so, as in this case demonstrates probably as well as any, creates a situation where the insurer, the employer, benefits substantially if the death is from a cause that from the work injury rather than from a cause that is not the work injury, and that was never intended.
Well,
and as
regardless of what they may have intended or regardless of what legislative history there is, you would agree that if the wording of the Act is clear, we follow that, wouldn't you?
Yes, and I think that is the point. Whether you take the 1921 version of the Act, which had it as one paragraph, and it starts out with should the employee die as a result of the injury, et cetera, and it's awarded benefits. And then the paragraph ended with should the employee die from some cause other than the injury, the liability for compensation shall cease. That was very clear. And if an employee dies from the injury, he or she receives benefits. If they die from a cause other than the injury, the liability would cease and they would not receive benefits. In 1972, there was a confluence of a variety of different things. Mainly—
Mr. Siegel, can I just stop before you go through
Yes.
legislative history? Because before you do that, can you just tell me where in the Act, what language supports your position that where a claimant dies of the injury, whatever benefits they would have received had they survived go to the estate?
That would, it goes to the estate or to someone who would be entitled to recover.
Where in the Act? Give me the
It's
citation.
306F.
It's 306F.
Yes, and this court cited that when it awarded benefits in the Scranton case in 1995, I believe, the city of Scranton case, and they said specifically that an award of benefits would follow. The court said in Scranton, and I can find, if you give me a moment, I'll have the language for you, but the court said it did not matter, and it was, we accepted review, and then they determined whether the appellant, the injured employee, was entitled to receive the specific loss benefits awarded or decedent prior to his death in 1995, but not payable until the disability ceased. That decision, interpreting 306F, was one that awarded benefits because it was—
Well, what's the language in 306F?
I can give you that. I don't have to find the specific of the whole language of it, but I can give it to you. Just 1 second. Should the employee die— well, the original language, which is what was in the Act, was should the original die—
What's the Act provide now?
It's 306, everything but. Let me find it's unclear, but it's the same language. Should the employee die, is payable under, his compensation shall be payable to his dependents under Section 307 of the Act, and shall
So that's payable to dependents?
Yes.
An estate is not a dependent?
Yes.
So where is the language in the Act currently that provides not only is it payable to dependents, but it's also payable to the estate?
I don't know if they say specific loss, but specific loss benefits accrue during the lifetime of the benefit, would accrue as a matter of course during the lifetime of the claimant.
But here the claimant passed away.
Right.
Before specific loss benefits were payable.
Right.
So again, I mean, I hate to be a stickler about this, but F deals with dependents.
Mm-hmm.
Where is the Act language that says upon death of a claimant who was awarded specific loss benefits, those benefits are payable to the estate?
It's the same language that would be 306G, which was for the non-dependent, for the non-work-related cause. It's identical language, but it said that covers the dependents. Let me find 306G for you, and then I can clarify.
I mean, because there is specific language there that says what happens when a claimant dies. And
Yes.
It says benefits are payable up to
Right.
the cost to the estate for purposes of covering funeral expenses.
Mhm.
Right?
Yes.
Is there another section
Yes.
that says there's an additional payment to the estate?
Yes, 306D.
306D.
When aware at the time of the injury, the employee receives injuries separate from those which result in permanent injuries, the number of weeks, et cetera. But that is the provision that awards benefits.
To the estate?
That would award benefits to the claimant or to any survivor, because that was the question this court addressed in Scranton, which was what happens when the employee dies and there is no heir.
Yeah, but in this case, he wasn't entitled to these specific loss benefits while he was alive.
She was not just as the same as Scranton.
Well, yeah, except for the fact that the benefits were paid for entitlement that occurred prior to death in that case.
No, they weren't. They were paid after death. And the question, as this court took it in 1995, was to determine whether the specific loss benefits awarded her decedent prior to his death, but not payable until his total disability ceased, and whether his death could operate as a termination of his total disability. And the court said no, that the court was entitled to that.
Well, if City of Scranton said that, why are we here?
Yeah.
Well, that's
I mean, obviously, I'm not trying to
tell you why we're here.
Why are we here?
We are here because when the when the Commonwealth Court in 2005 addressed it in the state of Harris, they didn't consider Scranton. It was never mentioned in the case. The legislative history in 1972 was never mentioned.
Well, again, but you keep wanting to go to legislative history.
Right.
I think we have to start with the statute that we have today.
Right. But it's the same statute as it was in Scranton and the same statute it was in Harris. And the only reason I believe that they were here is because that was never mentioned in the state of Harris. There's no other logical reason. There's no other reason for the court to have done as it did. Commonwealth Court simply didn't mention it and instead looked at the codification of Section 306G, which was titled, "Should the employee die from a cause other than the injury?" But that section was already in the Act when this court decided Scranton.
Scranton said the payments were made payable to his surviving spouse.
Yes,
Is
not
that a dependent?
to an estate.
Is that a dependent?
That was, but it was, she could be, but not necessarily.
Well, but I think that's the problem. I think the problem is the General Assembly clearly wanted to provide protections to dependents.
Yeah.
But when it went to create language in the Act to provide something for the estate, it specifically limited it to funeral expenses.
No, I don't.
I mean, isn't that why we're here? Scranton was a dependent case, not an estate case.
No, it was, it didn't matter because of the language was payable after, and the dependents wouldn't matter in Scranton, or in this case, if it were just the disability, the liability would cease, because she would not have been entitled to those benefits either. Specific loss are different from dependency benefits. Dependency benefits for an injured worker arise as a result of the state, the people, whether they're
but the section of the statute that gives the dependencies benefits applies to all categories of compensation
not
that are
specific
listed
loss.
above the, not specific loss?
No, specific loss is covered in a separate section. It's covered in Section 306, C, and that's separate from the dependency benefits.
And what does it say in 306C about estates?
It doesn't say anything. And then this court and other courts have interpreted it to mean disability after the award comes after the disability ceases. So in this case, it meant it would be after she died, because that was when her disability ceased, because she was never going to recover. She suffered the most horrid injuries she could and could never recover. Those benefits were then payable to her estate, just as they were in Scranton.
But they weren't paid to her estate in Scranton. They were paid to a surviving spouse.
Well, yeah, excuse me, spouse, right.
Right.
But they were not payable to the estate in Scranton.
Right, they were paid to the surviving spouse, presumably a dependent.
Yeah.
Maybe, maybe not.
When you look at the, also, the contemporary, and I know you want to look at the statute, and the statute is relevant because of what happened in 1972 that's been the case ever since. That was the cause of those amendments.
Yeah, but the only reason I'm suggesting looking at the statute now, unless you are arguing the statute's ambiguous.
No, I'm not suggesting the statute's ambiguous.
Then I'm not sure why we're talking about legislative history.
Because it's relevant to understand why the statute was amended and why it was changed so that it would eliminate the inequity that was done. Because the inequity was that states could, that the, specific loss benefits were payable when an individual died and suffered this, and had the specific loss benefits only after the estate, after the person died. And in those cases that came up, Swerdon and Kujawa, they both denied the benefits to an injured worker who died from a cause other than the work-related injury. The legislature was trying to cure that inequity, and the Supreme Court, in fact, when it also addressed Kujawa, pointed out numerous cases back then in the Superior Court where it was inequitable because in footnote 4, for example, they list numerous cases where death resulted after 3 years because you could not have a dependent, you can't have a dependency case after 3 years. Christina Steets died after 3 years. And in those cases, it was creating an inequitable situation. They did that to make that fairer, and it would be all. It shouldn't be because you die of a work-related injury and you get benefits, and if you die from a non-work-related injury, you don't get benefits. It certainly didn't mean that if someone dies because they happen to get cancer, they should get benefits, but the person who died from the injury does not get the benefits. That's inequitable. It's not, the whole humanitarian purpose of the act would not apply. And also, you do have to understand that specific loss benefits in this particular case were payable, and there would not be a death case because she died more than 3 years, excuse me.
Well, no, but look, the factual situations, the factual situations are terrible. We see that in workers' compensation cases all the time. They're terrible. But the result of the application of the clear and unambiguous language of the Act can't dictate the interpretation of the Act.
Yeah.
So that's why I started with the statute. You're saying it's clear and unambiguous. So I'm going to look at the statutory language and I'm going to see where does it provide for the payment under these circumstances.
And I did misspoke when I didn't cite section 410. 410 says that in case any claimant shall die before the final adjudication of his claim, the amount of compensation due to the claimant as the date of death shall be payable to the defendants or entitled, or if there be no dependents, then to the estate of the defendant.
But here her claim was finally adjudicated.
That's a question that's not clear.
Well, the definition of adjudication in the administrative agency law, which I think is incorporated by the Workers' Comp Act.
No, Workers' Comp Act does not. The administrative agency law is GRAP. GRAP does not apply.
The administrative agency law is not GRAP. GRAP is a completely different thing.
But it doesn't apply.
Rules.
But in this case, it's the same issue. It's not the same issue, but it's this.
How does the Workers' Comp Act define adjudication?
Its final adjudication has never been fully determined in the Workers' Comp Act. You have the series of cases, for example, which is where it usually comes up, which is when they plead a final adjudication, a termination was granted petition, but then the claimant appeals because the adjudication can only go against the claimant. Those cases have never been decided as to whether the adjudication is the adjudication of the workers' comp judge or if it's on appeal. So it's an open question. And I've always taken the position that as an open question, it went until the final appeal because the appeal board, Commonwealth Court, this court could adjudicate that and reverse. So it was not a final adjudication. But that's never been determined finally under the workers' comp law. That's one of those open questions. Sort of like it's the same issue in legal malpractice cases where it hasn't been finally determined whether the 2-year statute in a negligence case is from the date of the negligence or from the final date of appeals or appeals disposing of the matter. So you run into the same situation. But so I think I answered your question. Did I? I just want to make sure.
Yeah, I mean, I think there are other questions about 410 about whether the date of death, where did her specific loss benefit, right to specific loss benefits spring from? Did they spring on the day of death or after the day after death? I mean, that's your other problem with 410.
And I don't think they only.
Or do they ever spring at all? Really?
Yes, they spring, and the court said that in Scranton. But they spring on death, so it's after death. I don't know how you parse that question. I've never seen that raised before. But it's after death, and then they're payable.
Any further questions
No.
for Mr. Siegel? Okay. Let's hear from Ms. Doherty.
Good afternoon. May it please the court, my name is Sherry Doherty and I represent Celebration Fireworks in this case. This is definitely a very tragic case. We don't see these very, very serious injuries very often. But we are here today to ask this court to affirm the decision of the Commonwealth Court, which precluded the specific loss benefits being paid to Ms. Steets' estate. Some of the questions that were directed by the justices, I think, raised some of the issues that we have. We feel that Ms. Steets was provided with all of the benefits that she was due under the Workers' Compensation Act. She received total disability while she was injured. She received all of her medical care, including paying for inpatient medical care for several years. When she passed away, she had no dependents as they're defined by the Workers' Compensation Act, such as a spouse or dependent children. So there was no dependents to file a fatal claim petition to continue getting benefits. The Act provides for the payment of the funeral expenses, which were done by the carrier, but our position is that the specific loss benefits are not payable under 306, 307, or 410. I think that some of the comments made by counsel seem to try to put beneficiaries or heirs in the same category as a dependent. The Workers' Compensation Act is very specific as to who is a dependent under the Workers' Compensation Act. They also talk about the humanitarian purpose of the act or the remedial purpose. I don't think that applies in this case. Unfortunately, Ms. Steets is not here. Her benefits were paid up through her death, and there's no dependent out there that is being harmed by the decision of the Commonwealth Court. And that was what the remedial purpose of the act. There's only so far the act can go when they're determining
what categories of people are going to be covered by the Act. Obviously, you have the injured worker, but in cases of death, you also have a dependent spouse, dependent children, or even siblings or parents, so long as they're dependent on the injured worker. And here there's been a stipulation that there are no dependents. So I think that the main issues for the court to determine is whether Section 307, 306G, and 410 would allow the estate to receive any benefits. And
why doesn't Section 410 apply?
So 410 is actually a more general provision of the Act than 306 and 307. And if you have an individual who has no dependents, they would not be entitled to any benefits under 306 or 307. Under 410, I think you would have to determine, one, if there were benefits that were awarded after she passed away. As counsel stated, the issue of adjudication is somewhat interesting in this case. So there was a judge's decision in 2019 that Ms. Steets sustained specific loss of her arms. My client appealed that decision. It was affirmed by the board, the appeal board, and then it went to Commonwealth Court. The appeal to the Commonwealth Court was filed by my office in December of, I believe, 2020, and it was just weeks after that Ms. Steets passed away.
But she was getting paid while the appeals were pending. She was getting paid benefits.
She was receiving her total disability benefits
stay of the
up until she passed away. She was not missing any benefits. The specific loss benefits would be benefits that would be payable after she was no longer totally disabled. And I know counsel had referenced the case of City of Scranton, and I think that the way that our case is different than Scranton is, I think, as Your Honor said, I believe Scranton, the money was paid to a spouse or a dependent and not to the estate.
But he's relying on that case for another proposition, though, which is that the date of death was the end of the disability period, at which time the specific loss benefits would have kicked in.
Right.
That's the other proposition.
Right.
Why is that incorrect? I mean, if his reading of 410 would suggest that the final adjudication came at a point in time after her death, therefore the estate would be entitled to the benefits that were awarded because the disability period ended. Why is that not correct?
Right. The problem that you have is that, as I said, Section 410 is a less specific or more general provision of the Act, and we don't believe that the court can order the employer to pay benefits that are contrary to Section 306 and 307, which is what the claimant's side is asking us to do. They're basically asking us to rewrite the Workers' Compensation Act as it was amended in 1972, overrule the Estate of Harris case, which had almost exactly the same factual pattern as this case, and allow these benefits just because of the humanitarian purpose of the Act. So we're certainly sympathetic to Ms. Steets' family. This must have been something very, very terrible to go through, but there's nothing in the Act that provides for this money to go to the estate in light of the facts of this case.
Except for Section 410, if your opposing counsel's reading of 410 is correct. Isn't 410 intended to account for a situation where employer contests benefits?
Right, and so
and ultimately the employer was wrong. And so consequently, that's why it also applies for a penalty provision, which is how this whole case came up in the first instance.
Right, so as I said, I don't think that 410 applies here because it is contrary to 306 and 307. In terms of how specific laws.
It could apply if she was denied benefits by the workers' compensation judge and or the board, had an appeal pending in Commonwealth Court, passes away, and the Commonwealth Court then reverses the board and says she was entitled to benefits. Then somebody has to be paid her benefits up to death.
That may be a different situation.
But she was being paid benefits. She got an adjudication in her favor And after that, you didn't seek a supersedious from the Commonwealth Court, you paid her the benefits.
Right, we paid her the indemnity and medical benefits. The specific loss benefits were awarded by a judge about a year before she passed away. So it's a matter of...
They were awarded by a WCJ?
They were the specific loss benefits were awarded by a WCJ in a decision that my client appealed. The appeal ran up 2 levels up to the Commonwealth Court, and that decision was received after she passed away. So there is a question under 410 as to whether it was an adjudication in 2019 when the WCJ awarded her specific loss benefits, or were they awarded after her death because of my client's appeal. The other thing that I wanted to...
And in that case, the estate would be entitled to benefits.
I think that you'd still have to look at whether the benefits were due based on whether she had dependents or not. I think
so
that would have to...
So you would ignore the language that said, and if no dependents, then payable to the estate.
Right.
I mean, 410 takes into account the situation where there are no dependents.
Right. I mean, I think that really our position is that you have to go back and look at 306 and 307 to determine that the estate is not entitled to those benefits, and that 410 does not apply because she had already been awarded those specific loss benefits by WCJ.
Then 410 would never apply, because I think we've pretty firmly established that the Workers' Compensation Act, generally speaking, does not award benefits payable to an estate. It considers dependents as the payors in all circumstances. 410 seems to make a exception to that rule to prevent contests of claims.
Right. I mean, I've seen cases where it's a denied claim. The claimant files a claim petition for benefits, and during the litigation of the claim petition where they're receiving no benefits, the employer completely denies they were injured at work, they die, and you can continue to litigate that case and get a workers' compensation judge.
You don't get specific loss
right,
in that case.
That's a different...
You get what the statute says, benefits payable up to death.
Right.
Which is basically the indemnity payments, total disability payments, up to death.
Right, but if your death was caused by the work injury, if you have dependents, those dependents could file a fatal claim petition, which is an independent right to benefits, whereas the specific loss benefits are not an independent right to benefits for the dependents.
Unless 410 encompasses those specific loss benefits. I don't see anything in 410 that would preclude its application to specific loss benefits. I mean, it's a pretty general statement of what happens under certain circumstances. So it really comes down to when is the final adjudication.
Right, right.
Well, the 410 says up to the date of benefits to the date of death, right? So that's where City of Scranton comes in.
Correct. Exactly.
So 410 would provide benefits. That's a situation where someone isn't getting paid benefits while they're alive.
Right,
where she was. They die before the final adjudication. It was determined that they should have been getting benefits while they were alive, and it's payable to dependents or estates because they can't pay it to the claimant.
Exactly.
The question we have to resolve here, though, is whether up to the date of death, we also have to talk about what a final adjudication is, but up to the fatal date of death includes benefits that spring after total disability benefits are exhausted.
Right.
Which
so
is
I mean,
what City of Scranton dealt with.
Right. So I mean, the big question is what happens to the specific loss benefits when she passes away? There's no dispute under.
Well, City of Scranton would seem to say that specific loss benefits can be payable post-death.
Correct.
Not under 410, under a different section, but it would seem to say that.
Right, and I believe that was a situation where there was a dependent to receive those specific loss benefits. So that's why that case was a bit different.
Right, in 307 or 306, when it talks about dependents and death as a result of an injury other than the work injury, specifically references specific loss benefits.
Yes, that's correct.
Okay.
All right, Ms. Doherty, thank you
Thank
so
you.
much. Thank you both. Well done. Mr. Minner, would you call the last case?
Commonwealth of Pennsylvania versus Manuel Alejandro Rondon. Appeal of Stephen Hobbs, surety, representing Mr. Hobbs, Mr. Nicholas Kuczynski, representing the Office of the
tell me the proper pronunciation of Rondon? Is it Rondon?
Rondon.
Rondon.
It's Rondon.
Rondon. Okay, thank you. The appellant in this case, Stephen Hobbs, is a bail bondsman who posted $75,000 bail for Manuel Rondon. When Rondon failed to appear at a pretrial conference, the trial court issued an order revoking and forfeiting Rondon's bail. Several days later, however, the trial court reinstated Rondon's bail, finding that his failure to appear was due to court scheduling errors. Prior to reinstating bail, the trial court directed counsel to confer with Hobbs to confirm whether he agreed to continue as surety. Hobbs orally agreed, but did not provide written consent as required under Title 42, Section 5747.1. After Rondon failed to appear for trial, the trial court again issued an order revoking and forfeiting his bail. Thereafter, Hobbs filed a motion to set aside bail and exonerate him as surety on the grounds that he did not provide written consent to continue as surety. We granted review to consider whether the requirement of Section 5746.1 that a bail bondsman shall not be continued as surety on reinstated bail unless he provides written consent is triggered when the revocation and forfeiture of bail is the result of court order. You may proceed.
Good afternoon, Madam Chief Justice, Justices, Counsel. May it please the Court. I'm Nicholas Wachinski, and I represent the appellant this afternoon, Stephen Hobbs. As Chief Justice Todd just accurately described, the question before the Court is whether the written signed requirement is to extend the suretyship on a bail bond following the reinstatement of a bond is triggered when the reinstatement follows a revocation from a mistake or error.
Can I ask you a quick question?
Please.
Factually, I want to make sure I understand the facts because the Chief's recitation, I didn't. Was bail ever revoked?
Your Honor, the answer is yes, but if you will indulge me, I want to quick answer the question for the Court. I have some clarifications on the record that I think are going to be very important for the seven of you as I go into my argument, because it's beyond just the revocation. There are some other factual issues that I need to iron out.
Well, do you agree that bail, do you agree in this case bail was forfeited and revoked?
Bail was revoked and forfeited, correct.
Even though the trial court's order was any previous bail is forfeited, not revoked?
It was both revoked and forfeited under the operation of this statute and Rule 536. They're interchangeable.
You think bail forfeiture and bail revocation are the same thing?
I don't think they're the same thing. I think they're interchangeable, and I can explain why. Okay. Thank you, Your Honor. We hope to answer that question this afternoon, again, relating to the written requirement of that consent. The answer to that question is yes. Pursuant to Justice Brobson's initial question, I do want to clarify a few factual points. First of all, we have two different trial court, when I say trial court judges, there are two different trial court judges here. The time at issue that we're looking at is September 4th through September 29th of 2020. And that time period is important because on September 4th, Mr. Rondon and his counsel at that time waived arraignment. On the arraignment waiver, and this is important to understand because it will help understand what happened here. On the waiver of arraignment in Cumberland County, every defendant gets two dates, a pretrial conference date and a call of the list date. On September 16th, court administration moved those two dates and issued two new court notices, one for a pretrial conference on September 29th and one for call of the list on October 5th. Those are in your record at pages 20 through 29, reproduced record at pages 20 through 29. On September 29th, Mr. Rondon and counsel did not appear, and the bail court or the trial court issued a revocation and forfeiture. As is custom in Cumberland County, they're issued orally in court and then confirmed in writing either that day or as soon as they can be typed the next day. The 29th pretrial conference. That list began at 2 o'clock before Judge Peck, and the next day, President Judge Guido signed an order that said the bail was forfeited. We believe they're
revoked?
And revoked, yes.
Where's that order? You have that order's in the record?
The order is not in the record. We believe that Title 42, 57, 41, talking about how forfeitures are processed, where there's a revocation and a trailing forfeiture, that the revocation evolves into a forfeiture. If we look at, specifically, if we look at 5747.1B1, talks about how bail is revoked and then 91 days later becomes a judgment of forfeiture. This court, when it reviewed the statute in its contemporaneous amending of Rule 536, basically said, we agree. There was actually one dissent to that agreement, and that was you, Justice Donahue, at the time in 2016, saying we agree, so all forfeitures should be delayed to allow that process to unfold and to allow that 91-day period for a defendant to be returned.
Can we just go backwards for a second? Because I think there are a couple of assumptions or predicates that you're already at or past that I'm not quite there yet. The trial court found, as a matter of fact, that the fault here lay with court administration. I mean, we can agree with that. That's the trial court's
That's
finding.
what Judge Guido found almost 10 months later.
We're bound by that determination, aren't we? That's a fact finding, isn't it?
I think it is a fact finding. I'm not going to disagree with that, but I think in the nature of a de novo review, I don't know that this court is necessarily bound by it when the record is so replete with disagreeing information.
Well, the problem is that the reason I asked the question is if the trial court made, I understand it's a very messy, difficult situation here, but the trial court made that finding on the ground level, seeing what he saw. And if that is the case, then Rondon was not at fault. It follows that he wouldn't be at fault. And then we can't really say, I suppose, that he failed to appear as contemplated by this statute, which then leads me to the question. This is why I think you're already past me, so I need to get back to here. Because if he didn't fail to appear, we never get to subsection B of this statute. You know, he in other words, he upheld his contract with your client, and so then it would be kind of punitive to say, well, nonetheless, he has to go to jail and find a new bondsman. He abided by the provisions of the contract, and with the conditions of his release, the trial court screwed up. The court administration screwed up. What am I missing here?
What I'm struggling with, Your Honor, and to be frank, it's why we've brought this matter, is, as you just succinctly stated, this is messy, right, for a whole host of reasons. If you look at reproduced record, which includes transcripts of the trial court on the actual day when Rondon came to court, and then you look at what happened in the trial court's opinion some 10 months later, they seem to be at odds with one another, because the trial judge presiding at the revocation, really it's a Rule 150 hearing, right? It's a bench warrant hearing that happens because someone failed to appear. We're going to address the bench warrant. We're going to address bail. The trial court presiding at the bench warrant and revocation hearing on October 5th of 2020 says nothing about court mistake or error, and says, based on counsel's representation, I made the mistake, not court administration. Counsel for the defendant actually says in the record before the trial court, the mistake, confusion is mine as counsel. And he was reading from the actual court notices at the time. And then 10 months later, we have the court saying...
Yeah, but hold on a second. Let me back up to forget 10 months. At the October 5th hearing, wasn't your client consulted, Mr. Hobbs, and said he stood by the original bail?
He was not, Your Honor. My client was not in court that day.
I didn't say he was in court. Didn't the attorney of record say he spoke to the bail bondsman, and the bail bondsman stood by the bail?
We have an interesting anomaly in the record, Your Honor. He didn't speak to my client, and that is not...
That's a pretty simple question. Was Mr. Hobbs consulted, and did he agree to stand by it or not?
Mr. Hobbs did not. Counsel's representation...
So what action did he take between October 5th and ultimately the ultimate hearing, which happened several months later, to in pursuit of the bond.
He didn't take any action, Your Honor, until the second subsequent failure to appear happened, and the court tried to hold him liable on something he didn't consent to. And I think it's important to note from the record on October 5th, counsel for the defendant did not say to the court on the record, I spoke with Mr. Hobbs.
What did he say?
I spoke to the agency. My client maintains, and has never testified in this case, my client maintains he's never spoken to Attorney Narcissi.
So what action did your client take to actually pursue the defendant if he believed that the defendant was outstanding in that case and the bail had been sued out?
The bail hadn't been sued out, Your Honor, and the
Your
defendant...
client's got 90 days to find the defendant, right?
My client had 90 days to find the defendant.
So your position is from October 5th?
No, it would have been from September 29th.
Okay, so what did he take? What action did he take between September 29th and the date he ultimately failed to appear to find the defendant or locate the defendant to make sure his bail wasn't sued out?
At that point, Your Honor, Mr. Rondon wasn't at large. There wasn't an active warrant. There wasn't an active revocation. September 29th is the revocation 1. October 5th, Rondon and his counsel appear for call of the list.
Right.
The court addresses the bench warrant and the revocation when they appeared. To be quite candid, the notice of revocation and forfeiture required by 5747.1a had not even been sent to my client at that point yet. We didn't even have notice that Rondon had failed to appear on the 29th. So he comes in on October 5, and the bench warrant and revocation are addressed.
The bench warrant was withdrawn on October 5th.
Vacated, yes, Your Honor, correct.
And the bail was reinstated.
The bail was reinstated.
I'm still struggling with the fact that I don't see any order that says the bail was revoked.
Again, Your Honor, we maintain that...
You're maintaining that because it was you can't have a forfeiture without a revocation.
Correct.
You have to assume that it was revoked because the court used forfeiture.
Correct.
Okay.
And because, Your Honor, we maintain that provision because of both the statute and the rule, to Justice McCaffrey's point, gives a bondsman, any surety, frankly, whether it's a bondsman, mom, dad, grandmom, grandpap, doesn't matter. There's that 91-day period where the intention of the legislature was, go do your job, surety.
Was the bond ever paid over to the county?
No. Okay. It's not that the bond, again, I may misapprehend your question. Was the bond not paid over to the county as a matter of posting or at any subsequent point in time?
As a result of this proceeding, was your client, the first one, I'm not talking about the fact that he absconded again, but I'm saying the first time where this conversation took place and bail was reinstated. I mean, it's the language that, it's not as precise as I'm used to, and maybe it's just the nature of a criminal proceeding, but, it's, when bail was reinstated, at that point in time during that proceeding, had your client been out any money?
No, at that point in time, no. It's only because of the second subsequent, which we maintain he was not on the hook for at that point in time, because we have this breakdown. And again, to Justice Weck's point,
your point is he failed to appear, period.
Correct.
And that the judge excused his failure to appear doesn't mean he didn't fail to appear.
Justice Robson, you've picked up exactly where we're going. If you look to the trial court's record on the 5th, that's exactly what happened. Judge Peck accepted counsel's explanation as to why they weren't in court on the 29th. She went through the necessary steps. In fact, she actually went as far as to attempt to comply with the requirements for the writing by asking counsel to step out. To Justice McCaffrey's point, counsel for the defendant spoke. I don't know who he spoke to, but it certainly wasn't my client, Mr. Hobbs, as is required.
Counsel, pursuant to B, what is it, 5747(1)B, when Judge Peck reinstated the bail on that particular date,
correct.
The statute is a mandated requirement, the bail bondman shall not be continued by the court as surety unless a written consent is signed. So on that date, when bail was reinstated pursuant to 5747B, did your client sign a bail bond? A bail?
Thank you, Justice Doherty. The answer is no. Mr. Hobbs did not sign a written consent agreeing to the extension of the suretyship. And had he done that, Justice McCaffrey's question is well taken, right? There is a record of some conversation with someone, but the statute is clear. And let me make...
To Justice McCaffrey's point, I didn't mean to interrupt you, but now Justice McCaffrey's question is becoming very clear to me. After that happened, oh, you didn't know. You're saying your client wasn't notified of that hearing at all, had no notice of it at all.
Correct.
So the first time you heard that there was this earlier proceeding was when he actually absconded the second time.
Correct.
Okay.
So defense counsel misrepresented the fact to the court? He lied to are you saying he lied to the judge?
Justice McCaffrey, I do not want to suggest Mr. Narcissi misrepresented anything.
But hold on, I've been a trial judge. If a bail ordered sued out, and a defense counsel comes to me and says, Judge, we didn't get notice of this last week, 4 or 5 days ago. Lift the bench warrant, bail order's reinstated, right? Obviously, the surety's got to be notified of that particular fact because the bail's then reinstated. If the bail had not been reinstated, they would have 90 days to get him to court, correct?
Correct.
That's the whole purpose of what we're talking about here. So Mr. Narcissi said, I spoke to the bail bondsman. They agreed to remain as the surety in this particular case. Otherwise, the judge would have had to reset or impose new bail because you're telling me that the bail had previously been revoked or sued out, as we call it in Philadelphia. So there was no bail. So Judge Peck would have had to either set new bail or reinstate the bail.
Or keep the defendant in prison until the bail bondsman appeared pursuant to the statute
But
of assigned the consent.
If I may, Justice McCaffrey, I completely agree with your understanding of the process. And were that the process, we would be in a different capacity or standing where we are today. But I think the fundamental challenge that we're running into is, again, I am not in a position, I can't prove it, I wasn't there. I can't speak to whether he did or didn't, or who he did or didn't speak to, other than to say, it wasn't my client, Mr. Hobbs. And the record's clear. He didn't say I spoke to Mr. Hobbs. He didn't say I just hung up with Mr. Hobbs.
That doesn't matter, counsel. Your point, your argument doesn't spring from, you wouldn't be here differently if Hobbs was on the call. Your point is there's no written consent.
That's correct, but
so it doesn't matter who he spoke to. The fact of the matter is your argument is the statute requires a written consent for this very purpose.
Correct.
To avoid this discussion of who talked to who, when, and what consent was given.
And in the quest, would it be in the quest to do the right thing? Judge Peck didn't follow B requirement.
She did not follow through all the way to the end with B2.
Because it could be common practice within that county despite what the statute mandates.
It is common practice in that county, Your Honor, and frankly, to that. Correct. You have the 10% program in Philadelphia. And I think that that particular issue is important to speak to what Justice Brobson's earlier question is about revocation. There's actually a standard form which AOPC has generated, which, to my understanding, all but one county uses dealing with this. And it's a notice of intent to forfeit bail. That's actually an order of revocation and indicates a notice of intent to forfeit. That's what's generated in all the other counties, including Philadelphia now. Cumberland County is the only county that continues to issue this historical forfeiture order. It's the only county that I'm aware of.
Counsel, does it make any difference at all that this revocation was entered in error? I mean, as I understand the facts of this case, and the reason we have it, because we're dealing with an oddball situation where, you know, it really appears as though the defendant intended to appear when he was supposed to appear, and he did, but there were court orders that indicated that he should have appeared on a day 3 days earlier. So when the judge learned of that mistake, I mean, couldn't the judge just have said, I'm vacating the revocation? It was entered in error. I mean, I'm trying to figure out how your client was actually in any way prejudiced by anything that happened here in this 3-day period where the revocation was entered when it shouldn't have been.
The operative word is reinstated, not revoked.
Yeah, but couldn't they revoke? Couldn't the judge just have revoked it because of the error?
Well, if I may, that's actually something we speak at somewhat at length in our brief, and it's an important distinction, and it's actually an important distinction for 3 reasons, Justice Donoghue. You're talking about, and really I think this goes into earlier, I've had the benefit of listening to all your arguments, all of the arguments today, and you talked earlier about...
And they were interesting.
They were. And earlier today, you had some cases that talked about voiding things ab initio and the importance of records and the importance of what they all mean. And, you know, Justice McCafferty and Justice Dougherty have institutional experience in dealing with this, which is to say, anytime bail is set or reviewed in this Commonwealth by any judge, right, common pleas, magisterial, doesn't matter, one of the tenets that controls the decision on what the conditions are going to be, if any, or if there's a denial, as to Justice Dougherty's earlier point, is the history of failure to appear. If one looks at all of the rules related to bail and release on bail, specifically 523, 528, 526, failure to appear and the obligation to appear are replete throughout there. And to your point or your question, the reinstatement here serves three primary functions. Number one, to Justice McCafferty and Justice Brobson's point, we want to make sure that we have a surety in place. If there's a surety that's been required, is that surety in place, and are they going to continue as a surety? Because otherwise, we have a release on own recognizance, which we didn't intend. Number two, a defendant comes before the court on a future bail set. So let's say, hypothetically, Mr. Rondon catches a second case and has to have bail set. Or hypothetically, Mr. Rondon comes back. Let's assume that he comes back on this particular instance and bail is going to be addressed again. The court is going to look at the history of his performance when released on bail. And I think it's important to recognize that if this was a mistake, true mistake as has been suggested, and Judge Peck believed that on the day it was addressed, it should have been voided ab initio or nullified or stricken, at which point in time that order would have belied the need for reinstatement entirely, right? Because that would have been the trial judge on the day of dealing with the explanation and the justification saying, you got us, we made the mistake. And then the docket entries would mirror that, JNet would mirror that, and if a future bail judge would look at it, they wouldn't assume Mr. Rondon was non-compliant. With this just simple vacature of the bench warrant and then the reinstatement of a bail, my concern, and again, as a practicing criminal defense attorney, my concern is if that would be the policy this court adopts, we're going to allow generating inaccurate dockets where we really, to your point, we're talking about voiding out an erroneous revocation and warrant.
Would that be wrong?
Your point of view?
Yeah.
Absolutely not. 100% correct. I could, to be quite frank, I could not agree with you more.
But historically, correctly, factually, in your case, he was issued 2 subpoenas. He does not, the court, sua sponte, changes due to whatever purpose. 2 new subpoenas are generated. He's represented by counsel. On the day that he was supposed to appear, that he did not, or the day that he was not supposed to appear and he appeared, was his lawyer present?
No.
Okay. And then subsequently, on the date that he was supposed to appear, for which he had no notice, he didn't appear.
Justice Dougherty, with all respect, and I mean this, Justice Wecht couldn't have been more correct at the outset of this case. The record is messy. Again, arraignment is waived. This is reproduced record at 19. Arraignment comes out, a waiver of arraignment form comes out in Cumberland County. It has 2 dates on it. Pretrial, call the list. That's September 4. September 16, court administration moves those 2 dates. We don't know why. They changed the dates.
And they advanced them, right?
They advanced them.
They didn't push them back.
Correct. They advanced them.
Right.
They advanced them to September 29th for pretrial and call the list for trial. So he didn't have a date he shouldn't have been there. He had a date he should have been there. There was confusion by his attorney admitted to on the record, and then he shows up for call the list. And if you read in pari materia what is Exhibit B to my reply brief, and then the transcript contained in the reproduced record, or you can look at the transcripts that were forwarded on to you from the Superior Court. You look at them together, it's one continuing course of testimony with a break in the middle for a phone call. And again, to Justice McCafferty's point, I believe Attorney Narcissi made a phone call. I just don't know who he talked to.
Mr. Wachinski, could you wrap up, please?
Justice Dodd, I really don't have much more to say other than to say, you know, if I may, this court's precedent on...
No, I'm just... This entire discussion seems academic because it's based upon something that's not reproducible. You're telling me that Mr. Narcissi left the courtroom, called somebody, we don't know who it was, but that's the triggering event that Judge Christie Peck, we lifted the bench warrant and reinstated the bail based upon Narcissi's representation. This isn't a failure to have the consent agreement because your client wasn't notified because your client didn't know that the bail was sued out in this particular case because of Narcissi's representation to Peck. So, again, it's not a reproducible event. There's nothing for us to kind of opine on.
And unfortunately, that's the challenge. And to Justice Doherty's point, that's why the legislature intended the written consent, so we didn't have this kind of a breakdown. I mean, that is the challenge here. And to Justice Brobson's point, excuse me, I didn't mean to do that. To Justice Brobson's point, that's the whole purpose of the writing, is that we don't kind of deal with this challenge. I mean,
No, I don't disagree with anything you're saying. My point is that based upon what you're saying, Judge Peck should have said, Mr. Narcissi, I don't believe you. Get the bail bondsman over here right now to actually write keep
Well,
actually,
no, she should have said I need a consent in writing. The phone call's not enough.
Justices, if I may,
or get him over to the courtroom to actually give me a consent in writing.
If I may,
but she was actually cutting Mr. Narcissi and your client a break.
Yeah, correct. If I may, Justices, I'm trying to wrap up. I really am.
I know you are. I know.
I'll shut up.
No, because there's
you can talk after.
There's actually something important in the transcript that I think speaks to your concern, Justice McCaffrey. If you look at the transcript, one of the things that Narcissi came into the courtroom and said that kind of, it literally shocked me, was he came into the courtroom and said, I spoke to the agency. And again, let me be clear. Bail bond agencies are insurance agencies. There may be 17 bail bondsmen. There may be one. The reason we have the writing requirement from the bondsman is because the license inures to the bondsman, the suspension inures to the bondsman, the financial obligation inures to the bondsman, and their obligations with an insurer are specific to a person, not to some marketing tool, for lack of a better word, which is why the legislature was specific in the language it selected. But what he said when he came back in the courtroom, which kind of shocked my view of this, was he said, I've spoken to the agency, do you want the writing emailed or faxed? And she excused it. She said, I'll take your word for it. But again, he's counsel for the defendant. If I walked in as counsel for Mr. Hobbs, this may be a different, to your point, academic exercise, but I don't think, to Justice Brobson's point, I still don't think it excuses the writing requirement, because that's how we get over the ambiguity of whether consent was granted or not. And that's where this all kind of shocks me. And what even further surprises me is if you look in the record that we've provided, my clients provided a number of written consents to this county over the years, both agreeing to extension and disagreeing from extension. So the client knew the process. To Justice Todd's request, and I'm trying my best, I think the principles of statutory interpretation are well known to this court. And I relied on Reibenstein, counsel relied on Lopez, and I think in both of those instances, this court has been quite clear that you're disinclined to insert language into a statute or read ambiguity where none exists. The challenge in this court, to Justice Brobson's, Weck's, McCafferty's, Doherty's, Donohue's points are, we're dealing with a record that is messy. We're dealing with a calendar that is messy. I will say this as a footnote in sort of defense of the mess. Please don't forget what was happening in 2020. Rondon, even on October 5th, Rondon never appeared. Rondon was on a video screen. Rondon was home. So even on October 5th, if Judge Peck would have said, hold on a second, you're going to jail till I can get the bondsman here, it couldn't have happened because he wasn't in the courtroom. So with all that, I appreciate your questions. We'll rest on our briefs, and I hope I've answered all your questions.
Thank you. Thank you. Mr. Bialawa? The Cumberland County Office of Solicitor indicated by letter that the Cumberland County Board would not take a position in this matter and thus did not file a brief. The Office of Attorney General was invited to participate as amicus and did file a brief, and I believe you are that person.
I am that person.
Thank you.
Well, you found me.
Thank you for accepting our invitation.
And Madam Chief Justice, he is a person about whom I disclosed that he served as a law clerk to me. He's better dressed now.
Yeah, we won't hold that against him.
There were no, I received no objections from anybody.
We have no objection, and counsel could not have been a bigger gentleman throughout this process.
Thank you, thank you. Okay, please proceed.
May it please the court, Ricky Bilo on behalf of the Office of Attorney General. So the record is messy in this case, but the trial court's factual findings are very clear. The trial court said that there was no failure to appear that happened in September of 2020. The reason the record is messy to some extent is because there wasn't a transcript from the 2022 hearing, which formed the basis of the 1925A opinion. So the trial court, said that there was a mistake, there was scheduling miscommunication. The court administrator communicated something to Narcissi, it sounds like, that led him to believe he didn't have to show up until October 5th. And
before we get to October 5th, Mr. Bilo, can I just ask you, you said something a moment ago I want to check on. We can agree that Rondon and his counsel were given a subpoena for September 29, right?
Correct, yes.
And I mean, counsel admitted that at the hearing. And it's also clear that Rondon did not show on that date, right? He didn't show up on
That's
that.
correct.
So how is that not a failure to appear?
Because it seemed that there was some intervening event that's not apparent from the record that led Attorney Narcissi and Rondon to believe that they didn't have to show up until a later point in time. And it would seem that whatever that event was discussed at the 2022 hearing, and that we don't have a transcript of that hearing because it wasn't ordered.
And did he receive a notice for the change to October 5?
No, and not a formalized notice. Seems in the footnote, the court administrator said that, the trial court said that the court administrator has an informal practice of moving hearings around. And that informal practice is what led to the misunderstanding about when the appearance was required here. So from the defendant's perspective, it seemed that he didn't believe he had to show up until October 5th, not earlier.
How do you explain counsel's admission that the counsel did receive the subsequent notice with the change date, and the client felt me?
Yeah. So there's like a...
I mean, you're there because the person failed to appear at a notice date. Now, whether the notice caused that failure or whether something else caused that failure, it seemed like counsel pretty much said, yeah, we failed to appear, but here's why.
It seemed like he was going there. The transcript is a couple pages long, and it was over Zoom, and like it says, breaking up over the thing, and we don't really know what happened. And I just think that there is a big gap in the record, and that there was a hearing where that would, fill that gap, and we don't have that hearing, and I don't think that an appellant who doesn't order a transcript can use a gap in the record to their advantage. And I think that that's what disagreeing with the trial court's findings here would be.
Well, how do we differentiate? Well, the statute doesn't differentiate. The statute does not differentiate between a deliberate failure to appear and an inadvertent failure to appear, even if that inadvertence is caused by court error, right? I mean, there's no differentiation in the statute, is there?
No, the statute doesn't differentiate. And, if we're going to dispute a failure to appear also, I think that the rest of the statute matters as well. And I think that that's the initial triggering event of the statute, the failure to appear. But I think in...
Well, that's why I asked opposing counsel what I asked them earlier.
Yes.
I'm sorry, go ahead.
Yes, so in the remainder of the statute, it says other things that need to happen before bail can be reinstated and before written consent is required. So there has to be a notice of revocation, and that starts a 90-day period. But the bondsman needs to apprehend the defendant or find him in another jurisdiction's custody. That is what gives this statutory power to reinstate bail. There might be, under the rules of criminal procedure, other powers to reinstate bail and other things that are required. But under this specific statute, it's saying there was a failure to appear, and the defendant and the bondsman went out and apprehended the defendant, and because of that, the court now has power to reinstate bail. So when the court is reinstating bail for that reason, that's when the statute requires a bondsman's written consent.
Look, Counselor, I apologize. Under the statute, the only time, under the statute, the bail bondsman is mandated to sign the document is at its reinstatement. That is a condition subsequent to a court order revoking. The facts of this case is that there was a court order that was revoked. Whether it was an error or not, it was revoked, correct?
That's correct, Your Honor.
Which, as a result of that statute, the plain reading of the statute requires a written document for its reinstatement, for which the facts of this court, even in this muddled record, cannot prove.
Well, it's a plain reading if you ignore the parts that occur in between the statute. So it's saying a reinstatement that's happening because the defendant was apprehended and brought into custody. So in the, I'll flip to the statute, that'll make it easier. But it's saying, if the defendant is placed into custody, the revocation or release, where am I? Sorry. If the defendant is placed into custody or discovered to be in custody, the court shall set aside the bail, revocation, and may release the defendant with the reinstitution. So,
and then the next sentence, read that.
Yeah, so the bail bondsman shall not be continued by the court as surety on reinstated bail unless a written consent.
That's the line that's most important.
Yes, in the...
Share with me. Show with us, even in this muddled record, where that statute requirement was met by the bail bondsman.
It was not met in this case.
Then it's a cut and dry case.
Well, because it's saying reinstated bail, but it's talking about bail that was reinstated within the meaning of the sentence that precedes it. And that sentence is saying reinstitution because the defendant was apprehended or found by the bail bondsman. And you know, if you don't consider that context, then the statute doesn't make sense. But if you consider that context, it makes a lot of sense.
Now, was that the pandemic?
So the purpose of this written consent requirement is basically the same as the rest of the statute, and it's the statute saying, you know, let's encourage bondsmen to go out and apprehend defendants, so we don't need to use Commonwealth resources to do that. So the main way it's encouraging bondsmen to go out and apprehend defendants is saying, look, if you get them within 90 days, you don't have to pay anything, and it gives a schedule if they get them after 90 days. But the written consent requirement is part of that enticement as well for a bondsman to go do their job. Because it's saying, look, you went out, you got this guy, this guy's a proven flight risk right now. You shouldn't have to assume the responsibility for somebody that you know is a proven flight risk unless you agree in writing to do so. So it's really in that whole context. That's the purpose of the statute, is to protect a bondsman who's done their job. It's not triggered when a bondsman hasn't done their job in any way. And in this case, he didn't do anything. In fact, you know, so it is, even if we, you know, assume somehow that in the whole period that followed October 5th, that he didn't at all know he was responsible for Rondon, he certainly knew on July 7th, 2021, because that was the point where the defendant actually failed to appear. And at that point, a notice of revocation was issued. And the bondsman didn't come into court the very next day and say, okay, I actually wasn't supposed to be responsible for this. I had no idea who this guy was. He waited the 90-day period that he went out and tried to apprehend the defendant in the 90-day period, must have failed. And then when his, you know, his obligation to pay was imminent, that's when he decided to challenge his status as a bondsman. So I think that he was operating under the assumption, his conduct of waiting, not until the failure to appear, but waiting and much later than that to actually challenge it, shows that he did believe that he was the bondsman, and he was, because this statute doesn't apply unless he apprehended the guy in the first instance, and he didn't do that here. So yeah, that's pretty much everything about this case. And if nobody has any further questions, I know it's pretty late, and I'll wrap up.
Counsel, I have a question. What do you want us to do? What's our holding?
So the holding that I would like is that only when the procedures that are listed in subsection B, when those occur first, that's when written consent is required. So it would be that a defendant fails to appear, a notice of revocation is issued. After the notice of revocation is issued, 90-day period, bondsman goes out and apprehends the defendant or finds him in custody, bail is reinstated, and then written consent is required, only then is written consent required under the statute. That's,
Isn't arguably in this case, if defendant is placed into custody or discovered
To be in custody. Wasn't he discovered to be in custody?
so it says discovered to be in custody by the bail bondsman. And he wasn't discovered to be in custody by the bail bondsman. And I don't even know if he was discovered to be in custody.
I don't see where it says it discovered to be in custody by the bail bondsman.
In the
statute.
But he wasn't in custody. He didn't
I
get
don't-
taken into
on
custody.
October
did
5th, yeah, he was not in custody on October 5th.
Right. He just showed up for a hearing with his lawyer.
Yeah. And
That's because it should have been.
I am asking you to affirm. Yes. But,
Come on.
I mean, with a small, I think that the Superior Court's opinion is fine. I think that there could be a little more detail in saying that there is more than just a failure to appear that requires this statute to come into play. I think that you need the other things as well. And the Superior Court just said a failure to appear, but I don't even think if there was a failure to appear, that would be enough. So with that clarification, yes, absolutely affirm.
Okay, thank you both very
Thank you.
much.
Thank you, counsel.
Mr. Benner, would you adjourn?
Court is adjourned.